Babylonian and Assyrian Laws, Contracts and Letters by C.H.W. Johns, M.A., H.C. Torah Eek, Queen's College, Cambridge. Benersons, 1904. To my mother in memory of loving help. The P.E. Face. The social institutions, manners, and customs of an ancient people must always be of deep interest for all those to whom nothing is indifferent that is human, but even for modern thinkers engrossed in the practical problems of our advanced civilization, the records of antiquity have a direct value. We are better able to deal with the complicated questions of the day if we are acquainted with the simpler issues of the past. We may not set them aside as too remote to have any influence upon us. Not long ago, men looked to Greece and Rome for political models. We can hardly estimate the influence which that following of antiquity has had upon our own social life. But there is a deeper influence even than Greek politics and Roman law, still powerfully at work among us, which we owe to a more remote past. We should probably resent the idea that we were not dominated by Christian principles. So far as they are distinct from Greek and Roman ideals, most of them have their roots in Jewish thought. When a careful investigation is made, it will probably be found that the most distinctive Christian principles in our times are those which were taken over from Jewish life, since the Old Testament still more widely appeals to us than the New. But those Jewish ideas regarding society have been inherited in turn from the far more ancient Babylonian civilization. It is startling to find how much that we have thought distinctively our own has really come down to us from that great people who ruled the land of the two streams. We need not be ashamed of anything we can trace back so far. It is from no savage ancestors that it descends to us. It bears the hallmark, not only of extreme antiquity, but of sterling worth. The people who were so highly educated, so deeply religious, so humane and intelligent, who developed such just laws and such permanent institutions, are not unprofitable acquaintances. A right-thinking citizen of a modern city would probably feel more at home in ancient Babylon than in medieval Europe. When we have won our way through the difficulties of the language and the writing to the real meaning of their purpose, and come into touch with the men who wrote and spoke, we greet brothers. Rarely in the history of antiquity can we find so much of which we heartily approve, so little to condemn. The primitive virtues which we flatter ourselves that we have retained are far more in evidence than those primitive vices which we know are not extinct among us. The average Babylonian strikes us as a just, good man, no wild savage, but a law-abiding citizen, a faithful husband, good father, kind son, firm friend, industrious trader, or careful man of business. We know from other sources that he was no contemptible warrior, no mean architect or engineer. He might be an exceptional artist, modeling in clay, carving rocks, and painting walls. His engraving of seals was superb. His literary work was of high order. His scientific attainments were considerable. When we find so much to approve, we may naturally ask the reason. Some may say it is because right was always right everywhere. Others will try to trace our inheritance of thought. At any rate, we may accord our praise to those who seized so early in the history of the race upon views which have proved to be of the greatest and most permanent value. Perhaps nowhere else than in the archives of the old Assyrian and Babylonian temples could we find such an instructive exhibition of the development of the art of expressing facts and ideas in written language. The historical inscriptions, indeed, exhibit a variety of incidents, but have a painful monotony of subject and a conventional grandeur of style. In the contracts, we find men struggling for exactness of statement and clearness of diction. In the letters, we have untrammeled directness of address without regard to models of expression. In the one case, we have a scrupulous following of precedent. In the other, freedom from rule or custom. One result is that while we are nearly always sure what the contract said and intended, we often are completely unable to see why the given phrases were used for their particular purpose. Every phrase is technical and legal, to a degree that often defies translation. On the other hand, the letters are often as colloquial in style as the contracts are formal. Hence, they swarm with words and phrases for which no parallel can be found. Unless the purpose of the letter is otherwise clear, these words and phrases may be quite unintelligible. Any side issue may be introduced, or even a totally irrelevant topic. While the point of these disconnected sentences may have been perfectly clear to the recipient of the message, we cannot possibly understand them, unless we have an intimate acquaintance with the private life and personal relations of the two correspondents. Hence, quite apart from the difficulties of copying such ancient inscriptions, often defaced, originally ill-written, and complicated by the personal tastes of individual scribes for odd spellings, rare words, or stock phrases, besides the difficulties of a grammar and vocabulary only partly made out, the very nature of both contracts and letters implies special obscurities. But the peculiarities of these obscurities are such as to excite curiosity and stimulate research. The wholesome character of the subject matter, the absence of all possibility of a revision in party interests, the probable straightforward honesty of the purpose act like a tonic to the ordinary student of history. Nowhere can he find more reliable material for his purpose, if only he can understand it. One collection is chiefly composed of temple archives, another comes from a family deed chest, whereon such documents were preserved as were of value to the persons who collected them. At one period we may have a great number of documents relating to one sort of transaction. In the next period we may have hardly any reference to similar transactions, but very complete evidence regarding other matters. We may assume that in such a conservative country as Assyria or Babylonia, things went on forges in much the same way. Conclusions rightly drawn for early times are probably true for the later periods also. As far as we can test this assumption, it holds good. We may even assume that the converse is true, but that is more doubtful. Thus, we find that the practice of taking a pledge as security for debt is fully established for later times, and we may therefore hesitate to deny its existence in early periods, although we have no direct evidence on the point. This absence of evidence may be due to the nature of the early collection. It may also be due to the fact that the tablet acknowledging a loan was usually broken up on the return of the sum, but it might also be the fact that pledges were not usual in early times. Such was indeed formerly the conclusion drawn from the absence of documents referring to pledges. But Dr. B. Meissner pointed out that the legal phrase books bore witness to the existence of the custom. The discovery of the Code of Hammurabi has shown that the practice not only existed, was regulated by statute in his time. Hence, the argument from silence is once more shown to be fallacious. On the other hand, it is well to avoid a dogmatic statement of the existence of a practice before the date at which we have direct evidence of it. Thus, it has been stated that the tithe was paid in Babylonia from time immemorial. The only direct evidence comes from the time of Nebuchadrezzar II. And later, in view of such an early antiquity as that, the use of the phrase time immemorial was perhaps once justified, but we are now equipped with documentary evidence concerning customs 2,000 or 3,000 years earlier. Until we can discover some direct evidence there of tithe, we must content ourselves with saying that it was regularly paid under the Second Empire of Babylonia. We may be firmly convinced that a custom so widespread did not spring into being all at once, but the tithe may have been a composition for earlier dues, and as such may have been introduced from Chaldea by Nabopolassar. It may therefore not have been of native Babylonian growth. In this and many similar cases, it is well not to go beyond the evidence. To some extent, the plan of this work must necessarily be different from that of the rest of the series. When a historical inscription is once well translated, its chief bearings can be made out, and it is its own interpreter to a large extent. But the object in a contract is to legally bind certain parties to a course of action, and there its translation ends. We do not find much interest now in the obligations of these parties, save insofar as they illustrate the progress of civilization. It is the conclusion we are to draw which gives the interest. When we have reached that, 1,000 more contrasts of the same type add nothing to that point. We may use them to make a study of proper names, or to correct our notions of chronology by their dates, or to draw up genealogies, or even to elaborate statistics of occurrences, of particular forms of words, of prices, and the like, or try to reconstruct the topography of a town. But from the point of view of a student of law and history, 1,000 are little better than one. As a rule, however, we rarely find a fresh example of an old type without some small deviation, which is worth recording. But to translate it for the sake of that small difference would fill a book with examples, so similar as to be wearisome in their monotony. The only way then is to select some bold example, translate it as a fair average specimen, and then collect in an introduction and notes the most interesting additional items of information to be gathered from others of the type. Hence, most of the types here selected have involved the reading and study of scores of texts, though but one is given in translation. Other points of great interest arise, as for example, the obligations to public service, which are not the direct subject of any one text. Hence, no single example can be selected for translation. The data of many texts must be collected and only a sentence here and there can be utilized for translation. Hence, while other volumes of the series are properly translations, with brief introductions and a few notes, this must consist of copious introductions and many notes with a few translations. Of course, all technical, philological, and historical discussions must be avoided. Those who wish to find further examples illustrating the points given will be referred to the sources and commentaries which give almost endless repetitions of the same type. As a rule, a fresh example, which has not been translated before, will be used here. In some cases, however, where the most typical examples have already been used, they are reproduced. The more important and new details are substantiated by references and footnotes. When several references could be given, it has been the rule to give only one. For fuller information, the literature of the subject may be consulted, but where the Assyrian or Babylonian words are given, the reader will consult the lexicons first. There are many admirable glossaries attached to the editions of texts, which for students are a valuable supplement to the lexicons. All philological discussions are, of course, excluded. As a rule, doubtful interpretations will be ignored or at least queried. It is, on the other hand, impossible to give detailed proofs of what is certain to the writer when it disagrees with recognized authorities. Nor is it desirable to puzzle the reader with alternative views when there is no opportunity for him to judge of their merits. Every attempt will be made to discard non-essentials. Thus, in order to ensure that there should be no mistake as to the persons intended, the ancient scribe usually gave not only the name, but the father's name and often added the name of his tribe or his occupation. For example, Ardi, Ishtar, son of Ashur-bnei, the son of Gahal, might be the scribe's careful specification of one party to some transaction. But unless some other party is a relation, and the transaction explicitly concerns what could take place between relations, the whole line gives us no information of value for illustrating the subject for which it is quoted. Indeed, in most cases, the name itself is of no interest. It is true that the names have a value of their own, but that is aside from the purpose of this book. The examples are selected to illustrate legal points, not for the sake of the names. And indeed, the few interesting names so given would be insufficient to serve any useful purpose. They might even be misused, for no permanent results can be obtained by picking up here and there a name with some fanciful likeness to Abraham or Jacob, unless a complete list of similar names be available to check and control the readings. Hence, as a rule, the name of a party is condensed into a single letter, chosen usually in order to suggest the part played by the person in the transaction. Thus stands for the seller, B for the buyer, J for the judge, C for the creditor, L for the lender, D for the debtor or borrower, and so on. These abbreviations may be used without any detriment to the argument, as the context usually defines the relation and there is no need to remember what they mean. This seems preferable, for the most part, to the continental system of using AAG for the above name. As a further abbreviation, all lists of witnesses are excluded. The date is usually suppressed, for unless we are following a series of transactions between the same parties, nothing more than the epoch is of importance. As the material is arranged by epochs, there can be no question in this regard. If any evolution of process or any reference to former transactions is involved, so that the date is important, it is given. A collection of legal documents may be studied in a variety of ways. Perhaps the least productive plan is to ransack them for illustrations of a theory or a particular point. When the theory is already well known, as in the case of Common or medieval law, such a procedure is justifiable. But when the theory has to be made out, it is well nigh inexcusable. Some valuable monographs have followed this method, but they can hardly expect to give permanent results. For comparative purposes, our material is so new and so little worked that it is sheer waste of time to seek for parallels elsewhere. Unto everything is clearly made out to which parallels are to be sought. The whole bulk of material must be read through and classified. Until this is done, some important point may easily be overlooked. The first attempts at classification will be provisional. A certain amount of overlapping is sure to occur. For example, slave sales obviously form a provisional group, but slaves were sold along with lands or houses. Shall these sales be taken into the group? The sales of lands may be another group. To which group shall we assign the sale of a piece of land and the slaves attached to it? To answer that question, we may examine the sales of slaves and the sales of lands to see if either group has peculiarities, the recurrence of which in a sale of land and slaves might decide. But we soon find that a slave was sold exactly like a piece of land or any chattel. The only exception is that certain guarantees are expected with the slave, which differ from those demanded with a piece of land. On the whole, then, the chief group will be sales, with subdivisions according to the class of property used. Hence, we cannot assume that there was already present to legal consciousness a difference between real and personal property, or in any other sense that a slave was a person. He was a chattel. The classification which will be adopted is not one that will suit modern legal ideas. It depends on the form of document alone. If two documents have the same type of formula, they will be grouped together. A future revision YU no doubt assigned to many of these a place in modem schemes. But it is very easy to be premature in assigning an ancient document to modem categories. The groups will be subdivided according to subject matter. The order of the groups will be determined by the greater or less complexity of the documents. It is best to take those first proved we can be easily made out. The experience gained in discussing them will be of great service in dealing with more complicated cases. The reader must not, however, suppose that no obscurities will remain. Subsequent investigation will lead to redistribution. Each such revision will, however, bring us nearer to sound results. One of the most interesting and instructive methods of dealing with a large collection of documents is to grout together the transactions, distributed over a number of years, of one man or of a single family. This method has often been adopted and makes most fascinating reading. Thus, M.V. Cavelaut, in the appendix to M.E. Kevilou's lectures entitled Les obligations en droit égyptien to the power of une famille de commerçants, discussed the interrelations of a large number of tablets published by Strassmayer. These had a special connection, being found and practically kept together. They are concerned chiefly with the business transactions of three persons and their descendants. The three men do not seem to have been related, but to have become partners. The first transaction in which they are concerned is an equitable division of property which they had held in common. They and their descendants lived side by side in Larza and gradually extended their possessions on every side. They were neighbors to two wealthy landowners from whom and from whose descendants they gradually acquired lands and houses. Especially did two brothers, sons of one of the original three, buy up, piece by piece, almost all the property of these two neighboring families. Further, in acquiring a piece of land, they seem to have come into possession of the deeds of sale, or leases, of that plot, which had been executed by previous owners. Thus, we can, in some cases, follow the history of a plot of land during several reigns. Such a collection of documents probably did not come from the public archives, but from the muniments of a private family, or of a firm of traders. That duplicates of some of these tablets should have been found in other collections points either to the collections having been purchased from native dealers who put together tablets from all sources, or to the duplicates having been deposited in public archives as a kind of registration of title. In Assyrian times, the transactions of the great Rimdi-Nadadi, the chief charioteer and agent of Ashur to the power of Nepal, who for some 13 years appears almost yearly as buyer or seller, lender or borrower on some 40 tablets, may serve as a further example to the power of, or we may note how Bahi to the power of Nu appears, chiefly as a corn lender year after year for 33 years on some 24 tablets. For the Second Empire of Babylonia, Professor J. Kohler and Dr. F.E. Pizer have given some fine examples of this method. Thus, for the bankruptcy of Nabu Aplu Eddin, they show that the creditors distrained upon the bankrupt's property and found a buyer for most of it in a great Neriglissar, afterwards king of Babylon. The first creditor was paid in full, another received about half of the amount due to him, a third about the same, while a fourth obtained less than a quarter of what was owed him. They also follow out the fortunes of the great banking firm of Igibi for fully a century. The sketch, of course, is not complete and can only be made so by a prolonged search through thousands of documents in different museums. But it is intensely interesting and written with wonderful insight and legal knowledge. Another example is the family or guild of the priests of Gula. This is less fully made out but most valuable as far as it goes. In both cases, a genealogy is given extending over many generations. Later still, the Babylonian expedition of the University of Pennsylvania, in the 9th volume of cuneiform texts, gives a collection of the business documents of one firm, Marashu's sons, of Nippur, in the reign of Artaxerxes I. Here we have to do with a family deed chest, a collection of documents found together and fortunately kept together. But this method, attractive though it is, cannot be followed here. The reader is best led on from the novum to the unknown. Those things must be taken first, which must be understood, in order to appreciate what is placed later. We consider first the law and the law courts. The reader can thus follow the references to procedure which occur in the other sections. The rights of the state, the family, and the private individual come next. Then we learn of the classes of property and the various ways of disposing of it. After that is taken up a variety of disconnected topics, whose order is mainly indifferent. Some overlapping of divisions is sure to occur in any order. This system has been found, after many permutations, to present the least inconvenience. While it is hoped that this volume will give a fairly complete account of what is really known, and also point out some things that are reasonably conjectured to be true, it is fully recognized that much remains to be done. Indeed, it may serve by its omissions to redirect attention to openings for future fruitful work.
Sources and bibliography.
Character of the available material. The chief sources from which is derived our knowledge of Babylonian and Assyrian law are the contemporary inscriptions of the people themselves. These are not supplemented to any appreciable extent by the traditions of classical authors. So far as they make any references to the subject, their opinions have to be revised by the immeasurably greater knowledge that we now possess, and seem to be mostly based upon travelers' tales and misapprehensions. These inscriptions are now preserved in great numbers in European and American museums and have only been partly published. The bibliography is very extensive. For the earlier attempts to read and explain these documents, the reader may refer to Professor C. Bezold's Überblick über die Babylonische Baster Assyrisch Verlitter, which gives a fairly complete account up to 1887. Of course, many books and memoirs there mentioned have now only a historical interest for the story of decipherment and explanation. These, however, may be studied with the greatest profit after having first become acquainted with the more recent works. Division of subject. The division which is adopted in this work, law, contracts, and letters, is only conventional. The three groups have much that is common and mutually supplement one another. Previous publications have often treated them more or less together, both as inscriptions and as minor sources of history. Hence, it is not possible to draw up separate lists of books treating each division of the subject. Only those books or articles will be referred to which are most valuable for the student. Many of them give excellent bibliographies of their special subject. Laws and contracts. The contemporary sources include actual codes of law or fragments of them, legal phrase books, and legal instruments of all sorts. From the last mentioned source, almost all that is known of ancient Babylonian law has been derived. The historical and religious inscriptions contribute very little. The consequence is that, except from the recently discovered code of Ichkaran Ukamarabi, scarcely anything is known of the law in respect to crimes. Contracts and binding agreements are found in great profusion, but there is nothing to show how theft or murder was treated. Marriage contracts tell us how adultery was punished. Agreements or legal decisions show how inheritance was assigned. Consequently, our treatment of law and contracts must regard them as inseparable, except that we may place first the fragments of actual codes which exist. Letters. The letters are much more distinct. Each is a separate study, except insofar as it can be grouped with others of the same period in attempts to disentangle the historical events to which they refer. The deductions as to life and manners are no less valuable than those made from legal documents. In both wording and subject matter, They often illustrate legal affairs and even directly treat of them. Chronologically treated, a first duty will be carefully to distinguish epochs. Great social and political changes must have left some mark upon the institutions we are to study. As far as possible, the material has been arranged for each subject chronologically. The longest and by far the most important ancient code hitherto discovered is that of H.B. Karan UK Marabi, circa 2250 BC. The Code of H.B. Karan UK Marabi. The source for this is a block of black diorite about 2.25 meters high, tapering from 1.9 to 1.65 meters in circumference. It was found by De Morgan at Susa, the ancient Persepolis, in December 1901 and January 1902, in fragments which were easily rejoined. The text was published by the French Ministry of Instruction from squeezes by the process of photogravure in the 4th volume of the Memoirs de la Délégation en Perse. It was there admirably transcribed and translated by Professor V. Scheil. In all, the monument now preserves 44 columns with some 3,600 lines. There were 5 columns more which were once intentionally erased and the stone repolished, probably by the order of some monarch of Susa, who meant to put his own name and titles there. There have been found other monuments in the French explorations at Susa, where the Elamite monarch has erased the inscription of a Babylonian king and inserted his own. This method of blotting out the name of a king was a favorite device in the ancient East, and is frequently protested against and cursed in the inscriptions set up in Babylonia. This particular inscription did not fail to call down similar imprecations, which perhaps the Elamite could not read. But he stayed his hand, and we do not even know his name, for he wrote nothing on the vacant space. It seems probable that the stone, or at any rate its original if it be a copy, was set up at Sippara. For the text speaks of Ebara Swati, this Ebara, which was the temple of Shamash at Sippara. At the head of the obverse is a very interesting picture of H.B. Karanu, Kamrabi, receiving his laws from the seated sun god Shamash. Some 700 lines are devoted to the king's titles and glory, to enumerating the gods he reverenced and the cities over which he ruled, to invoking blessings on those who preserved his monument and respected his inscription, with the usual curses on those who did the opposite. These belong to the region of history and religion and do not concern us here. We may note, however, that the king expected that anyone injured or oppressed would come to his monument and be able there to read for himself what were the rights of his case. Later copies. The whole of this inscription is not entirely new matter. The scribes of Ashurbanipal somewhere found a copy or copies of this inscription and made it into a series of tablets. Probably their originals were Babylonian tablets, for we know that in Babylonia, the code had been made into a series which bore the name of Ninu Ilu Sirum, from the opening words of the stele. But, judging from the colophon of the Assyrian series, the scribes knew that the inscription came from a stele bearing the image of H.B. Karan UK Marabi. A number of fragments belonging to such copies by later scribes were already published by Dr. B. Meissner and Dr. F.E. Pizer. These were further commented upon by Professor Frank Delitzsch, who actually gave them the name Code Hammurabi. Some of these fragments enable us to restore 1 or 2 sections of the lost 5 columns. These fragments are now easily set in order and will doubtless lead to the discovery of many others, the meaning of which has not yet been recognized. They exhibit some variants of interest, showing that they were not made directly from this particular monument. Even at Susa, another fragment was found of a duplicate stele. Hence, we may hope to recover the whole text before long. Biography of this code. The publication of the code naturally excited great interest among scholars. It appeared in October 1902, and, during the next month, Dr. H. Winkler issued a German translation of the code under the title Die Gesetze Hammurabis Königs von Babylon, 2250 v. Christus alte Gesetzebuch der Welt, being Heft of the 4th Jahrgang of der Alte Orient. This marked an advance in some points on Scheil's rendering, but is not entirely satisfactory. The present writer read a paper in October 1902 before the Cambridge Theological Society, an abridged report of which appeared in the January Journal. He further published a baldly literal translation in February 1903 entitled The Oldest Code of Laws in the World, one in the Journal des Savants for October and November 1902, Dersti gave a luminous account of the subject matter of the code, especially valuable for its comparisons with the other most ancient law codes. This, of course, was based on Scheil's renderings. In the Orientalistische Literaturzeitung for January 1903, Dr. H. Winkler, reviewing the fourth volume of the Memoirs, gave a useful account of the code, comparing it with some of the previously published fragments. Mosaic parallels. The comparison with the Mosaic Code was sure to attract notice, especially as Professor F. Delitzsch had called the attention of the public to it in his lecture entitled Babel und Bibel, even before more of the code was known than the fragments from Nineveh. Dr. J. Jeremias has published a small book called Moses und Hammurabi, in which he deals with the relations pretty thoroughly. Professor C. F. Kent has also examined them in his article entitled The Recently Discovered Civil Code of Hammurabi in the Biblical World for March 1903. Some remarks on the subject are to be found in the New York Independent, December 11, 1902, and January 8, 1903, accompanying a translation. All the above follow Winkler's renderings. The translation here given makes use of the above works, but must be regarded as independent. It is impracticable to detail and justify the changes made. The renderings can hardly be regarded as final, where actual contracts do not occur to illustrate the code. But there is very little doubt that we know the tenor of these laws with substantial accuracy. Professor V. Scheil divided the text of the code into sections according to subject matter. But there are no marks of a division on the monument, and Scheil's division is not adhered to in this work. For convenience of reference, however, his original section, Numbers, are given in connection with each law or subsection of a law. The legal phrase books among the treasures preserved in the library of Ashurbanipal and in the archives of the Babylonian temples were a number of tablets and fragments of tablets, which recorded the efforts made by Semitic scribes to render Sumerian words and phrases into Semitic. A large number of these are concerned with legal subjects. A fairly complete list of those now in the Koyujic collections of the British Museum will be found in the 5th volume of Dr. Bezold's catalog, page 2032. The greater part of them have been published either in the British Museum Inscriptions of Western Asia, in Dr. P. Haupt's Kalisch Schrifttekten, ios Texika. In the latter will be found references to other publications. Dr. B. Meissner further published a number of later Babylonian editions of the same or allied series. Their plan, the plan of the series to which most of these tablets belong, is well seen in Dr. Delitzsch's Assyrisch Lesestück, 4th edition, page 112-14. The name by which the series is usually known, to which most of these tablets belong, is the Semitic rendering of the first Sumerian phrase given there, Ana Itisu, to his side. The sections into which the series is divided each deal with some simple idea and its expression in, but the principle of arrangement is not very clear. We may take one section, for example. With him, with them, with me, with us, with thee, with you, are given in 2 columns, the first being the Sumerian for these phrases, the second, the Semitic rendering. Owing to the form of treatment, some of these texts have been called paradigms, Sumerian family laws. But the scribes also gave some fairly long and connected prose extracts in Sumerian with their Semitic renderings. What these were extracted from is still a question. Some of the clauses are known to have been employed in the contracts, but some of these even may well have been extracts from a code of laws. The name of Sumerian family laws has been given to certain sections. Others seem to have been extracted from a Sumerian work on agriculture, with which Hesiod's Works and Days has been compared. But at present we are not in possession of the complete works from which these extracts are taken. Such as they are, they have a value beyond that of enabling us to read Sumerian documents. They often afford evidence of customs and information which we get nowhere else. The information given by them will be utilized in the subsequent portions of this work. Their translation here would serve no purpose since they are very disconnected, but an example may be of interest. One section reads, "He fastens the buckets, suspends the pole, and draws up the water." This is a vivid picture of the working of a watering machinery, from which we learn its nature as we could not from its name only. Legal documents. Legal documents constitute by far the larger portion of the inscriptions, which have come down to us from every period of Babylonian and Assyrian history. In the library of Ashurbanipal alone, they are exceeded by the letters and even more by the works dealing with astrology and omens. In some periods, however, we have only a few inscriptions from monuments or bricks. Real character of the contract tablets. To some extent, the term contracts, which has commonly been applied to them, is misleading. The use of the term certainly was due to a fundamental misunderstanding, they being once considered as contracts to furnish goods. They were even thought to be promises to pay, which passed from hand to hand like our checks, and so formed a species of clay money. These views were both partially true, but do not cover the whole ground. They were binding legal agreements, sealed and witnessed. They were binding only on the parties named in them. They were drawn up by professional scribes who wrote the whole of the document, even the names of the witnesses. Hence, it is inaccurate to speak of them as signed by anyone but the scribe, who often added his name at the end of the list of witnesses. The parties and witnesses did impress their own seals at one period, but later one seal, or two at most, served for all. It is not clear whose seal was then used, but the document usually declares it to be the seal of the party resigning possession. Their external form. As to external form, most of those which may be called deeds consist of small pillow-shaped or rectangular cakes of clay. In many cases, these were enclosed in an envelope, also of clay, powdered clay being inserted to prevent the envelope adhering. Both the inner and outer parts were generally baked hard, but there are many examples where the clay was only dried in the sun. The envelope was inscribed with a duplicate of the text. Often the envelope is more liberally sealed than the inner tablet. This sealing, done with a cylinder seal running on an axle, was repeated so often as to render its design difficult to make out and to add greatly to the difficulty of reading the text. When the envelope has been preserved unbroken, the interior is usually perfect, except where the envelope may have adhered to it. Such double tablets are often referred to as case tablets. The existence of two copies of the same deed has been of great value for decipherment. One copy often has some variant in spelling or phrasing, or some additional piece of information that is of great assistance. The envelope was rather fragile and in many cases has been lost, either in ancient times or broken open by the native finders in the hope of discovering gold or jewels within. But in any case, the envelope, so long as it lasted, was a great protection, and there are few tablets better preserved than this class of document. In Assyrian times, few case tablets are preserved. They seem to have gone out of fashion except for money loans and the like. But it may be merely an accident that so few envelopes are preserved. In the case of letters, where the same plan of enclosing the letter in an envelope was followed, hardly any envelopes have been found, because they had to be broken open to read the letter. The owner of a deed may have had occasion to do the same, but here there was less excuse, as the envelope was inscribed with the full text. In early times, another method of sealing was adopted. A small clay cone was sealed and the seal attached to the document by a reed, which ran through both. The seal thus hung down, as in the case of many old parchment deeds in Europe. How kept the deeds were often preserved in private houses, usually in some room or hiding place below ground. In the case of the tablets from Tel Sifr, which were found by Loftus in situ, 3 unbaked bricks were set in the form of a capital U. The largest tablet was laid upon this foundation, and the next 2 in size at right angles to it. The rest were piled on these and on the bricks, and the whole surrounded by reed matting. They were covered by 3 unbaked bricks. This accounts for their fine preservation. Others were stored in pots made of unbaked clay. The pots, as a rule, have crumbled away, but they kept out the earth around. Sometimes this broke in and crushed the tablets. In some cases, they were laid on shelves round a small room, but in others they seem to have been kept in an upper story and so were injured when the floor fell through. The parties possessing copies, it seems certain that as a rule all deeds were executed in duplicate, each party receiving a copy. The scribe often appears to have kept another. At one time, copies were also deposited in the public archives, most probably the city temple or the governor's palace. There are indications that copies of deeds executed in the provinces were sent to the capital. Whether this was in pursuit of a general policy of centralization or only accidental in the few cases known to us is not quite clear. In many instances, we actually possess duplicates, sometimes 3 copies of the same deed. Scope of legal documents. These documents are exceedingly varied in contents. The most common are deeds relating to the sale or lease of houses, fields, buildings, gardens, and the like, the sale or hire of slaves and laborers, loans of money, corn, dates, wool, and the like, partnerships formed or dissolved, adoption, marriage, inheritance, or divorce, but almost any alienation, exchange, or deposit of property was made the subject of a deed. Further, all legal decisions were embodied in a document, which was sealed by the judge and given to both parties to the suit. These were often really deeds by which the parties bound themselves to accept and abide by the decisions. Some are bonds or acknowledgments of debt. A great many closely allied documents are lists of money or goods which had been given to certain persons. They were evidence of legal possession, and doubtless a check on demand for repayment. General works on the subject. The bibliography of the subject is best dealt with under each general division, but reference must be made to works dealing with the subject as a whole. Professor J. Oppert's Documents juridiques was the first successful attempt to deal with contracts in general, and laid the foundation of all subsequent work. Dr. F. E. Peiser and Professor J. Köhlers aus Babylonischen Rechtschreiben deals with the later Babylonian documents as far as they throw light upon social life and custom. Professor Sayce's Babylonians and Assyrians makes large use of the data given by the contracts. Dr. T. G. Pinches's The Old Testament in the Light of the Monuments of Assyria and Babylonia also gives a very full account of what may be gleaned from them. The present writer's Assyrian Deeds and Documents makes an attempt to treat one branch fully. This work can only present the most essential facts. The whole amount of material is so vast, so much is yet unpublished, so many side issues arise, all worth investigating, that it can only serve to introduce the reader to a fascinating and wide field of study. Different epochs represented. The material with which we have to deal, for the most part, falls very naturally into epochs. The early Babylonian documents, though very numerous, are mostly of the nature of memoranda, and include few letters or contracts. The documents of the first dynasty of Babylon are extremely rich in examples of both contracts and letters. Then, the Tel Amarna letters form a distinct group. The Ninevite contracts and letters of the Sargonid dynasty are well marked as separate from the foregoing. Lastly, those of the New Babylonian Empire are a group by themselves. A few scattered examples survive which form intermediate groups, usually too small to be very characteristic, and certainly insufficient to justify or support any theory of the intermediate stages of development. Local features. It must be observed that to a great extent these groups are not only separated by wide intervals of time, several centuries as a rule, but that they are locally distinct. The first comes from Tolo, the larger part of the second from Sippara, the third from Egypt or Syria, the fourth from Assyria, the last from Babylonia. Whether the documents of Sippara in the third period showed as great divergence from those of the second period as the Tel Amarna letters do, or whether each group is fairly characteristic of its age in all localities, using the cuneiform script, are questions which can only be answered when the other documents of that period are available for comparison. Characteristics of each group. The documents of each group have marked characteristics in form of script, in orthography, in language. So great are the differences that a slight acquaintance with these characteristics will suffice to fix the epoch of a given document. For the most part, however, these characteristics are not such as can appear in translation. They will be pointed out as far as possible in the opening sections dealing with each group. The aim will be to select characteristic specimens of each group for translation, and to append a summary of what can be obtained by a study of the group. The thousands of documents dealt with under these groups would, if translated, require a library of volumes. In the case of the contracts, the repetition of scores of examples of the same sort would be wearisome. In the case of the letters, the translation alone would be almost as obscure as the original, without copious comment on the relationships, customs, and events referred to. In both cases, it must be noted that many of the most interesting examples are incomplete and unavailable as specimens. The object of this work is to show what are the most important laws or legal documents of each period, and to point out the chief subjects of information to be gained from them. For the letters, no such summary of information can be given, partly because they are so many and varied, partly because so few are yet available. First period, the early Babylonian, the first epoch, is to be considered as one period only because its contribution to the subject is as yet small and chronologically precedes the first great group. It ranges from the earliest beginnings of history to somewhere about BC 2300. The dates are largely conjectural, but for the most part, the sequence of the events is known. It is the period covered by Dr. H. Redow's Early Babylonian History. Some very ancient documents fall under this period. The early tablets, which show the nearest approach to the original picture writing, are transfers of property. As a rule, however, such votive inscriptions do not come under the head of contracts. One of the earliest of our monuments, the Still of Manistusu, king of Kish, records the sale of land. Another very early monument of similar style deals with the sale of plots of land. Others will be found in the Memoires de la Délégation per se. But by far the greatest number of inscriptions belong to the finds of Tello, made by de Sarzide in his explorations for the French government. His greatest find, some 30,000 tablets which were in the archives there, was dispersed by the Arabs and has found its way into various museums. They have been sold in Europe as coming from different localities. It is certain that other finds of the same period and same general character have been made elsewhere, so that it is often difficult now to determine their place of discovery. A very large number of these tablets, from the collection of T. Simon, now in the Berlin museums, were copied and edited by G. Reisner as Tempelurkunden aus Tello. The admirable abstracts of the contents there given, too, will furnish all the information that anyone but a specialist will need. They consist of lists of all sorts of natural products, harvests from fields, seed and other expenses allowed for cultivating fields, lists of the fields with their cultivators, numerous receipts for loans or grants, accounts of sheep and cattle, stipends or allowances for certain people. But only one, number 125, is doubtfully said to concern a sale of some slaves. Dr. H. Redow, in his Early Babylonian History, gives the texts of a large number of similar tablets. He also classified, transliterated, and tentatively translated most of them. The kind of information to be obtained is well brought out in his notes and comments. They contain receipts, accounts of all sorts, lists of animals, skins, wool, oil, wine, grain, pitch, and honey, but none relate to the usual subjects treated in contract tablets. Mem Torodengin edited and discussed a number of tablets of the same character in the Revue d'Assyriologie 1. Especially valuable is his memoir, La Comptabilité agricole en Chaldée, 2, where many interesting facts are collected and published. The second period, the first dynasty of Babylon. A very large number of texts of this period were published by Mr. L. W. King in cuneiform texts from Babylonian tablets, etc., in the British Museum. These have been discussed in a few instances by various writers and scientific journals. In the short descriptions prefixed to these editions, mention is made of contracts, but it is difficult to see to which the term could be properly applied. A number of extracts from early contracts are given by Professor V. Scheil in the recent files of the Reçu des Travaux. According to the descriptions given, many of them are legal instruments. Besides advances of grain and receipts for the same, or sales of land, we have a legal decision concerning a marriage. Of several of these, only a few lines are given, and the description of others is misleading. They are mostly preserved at Constantinople. Some are purely Sumerian, others Semitic. The same remarks apply to this author's publications in his Une saison de fouet à Sippar. Valuable as are the portions available, they chiefly make us long for more. A very large number of tablets belonging to the second period are now in Europe and America. They seem to have been purchased from dealers either in the East or West, and may be presumed to have been discovered by the natives. No reliable information can therefore be had as to their origin. Various places are mentioned: Sippara, Abu Haba, Senkere, Tela, Warka, have all been stated to be the place of discovery. There seems no good reason why tablets of this period should not be found anywhere in Babylonia. But, on examination, it is found that collections said to be from widely different places contain duplicates, while the same collection contains tablets dated at different cities and with dates 1,000 years apart. It is conceivable that the records of important transactions, especially the transfers of land, were deposited by order in the archives at the capital, wherever that was for the time being. We may imagine that the archives at Sippara or Larsa were afterwards transferred to Babylon for safety, or in pursuance of a policy of centralization. Certain it is that a large number of the texts imply a devotion to Shamash as chief deity, while others ascribe the preeminence to Marduk or Sin. But this fact is quite consistent with the archives having been discovered in either Babylon or Sippara. Present location of the tablets: London. On the other hand, it is not unlikely that the apparent centralization is of purely modern production. The dealers put together tablets from all sources and ascribe the collection to the place of origin which best suits their fancy. As a consequence, scarcely any collection contains a homogeneous series belonging either to one period or source. This is the more deplorable because so few are competent to date a tablet by the style of writing upon it, and internal indications are often lacking. In the British Museum we have the following collections. 1. A number of case tablets brought from Telsifer by Loftus in 1850, owing to a misleading statement in Layard's Nineveh and Babylon, page 409. Page 6. These have generally been taken to be from Warka, the ancient Erech, but the account given on pages 270-72 of Loftus' travels and researches in Chaldea and Susiana leaves no doubt of the place and date of their discovery. These are usually denoted by B. 2. A number of tablets now in the Koyunic collections. It is certain that these do not come from Nineveh, and in the British Museum catalogue they are usually ascribed to Warka, but with an implied doubt. 1 or 2 are dated at Erech. The DT collection also contains many tablets said to be not from Koyunic. 3. The collection July 1st, 81 contains some 40 at least, comprising the accounts of the Temple of Ninib from the time of Amiditana and Amizadaguga. 4. The collection July 14th, 82 also has a few tablets of this period. 5. The collection September 18th, 82 has at least one contract. 6. The collection Boo, May 18th, 88, purchased by Dr. E.A.W. Budge in the East, consists of some 700 tablets. They are said to come from Sippara and date from BC 2300 to the time of Darius. These will be denoted by B. 7. The collection Budge, May 9th, 91, also purchased by Dr. E.A.W. Budge in the East, consists of some 3,000 tablets. These will be denoted by B2. The purchases for the British Museum also include a large number of other tablets of this period. They are now numbered consecutively, thus Boo 91, 5, 96, 06 is known as Brit Must No 92,679. This renders it difficult to further particularize the contents of the collections. Paris, in the Museum of the Louvre at Paris, are a few tablets belonging to this epoch. 7 of them are published in M. Hoysi's Découverte and Chaldee. At the Berlin Museum is a collection known by the name of Homsi. The tablets are marked V.A. Thi, but this mark includes other tablets widely separated in date and found at different sites. Philadelphia, at the University of Pennsylvania collections, known as J.S. Cake and H, contain tablets of this period. Professor R.F. Harper, writing in Hebraica, gives some account of these collections, from which it appears that the J.S. collection contains tablets of H. Karan Ukemarabi, Samsuluna, and Amiditana, while the K.S. collection has tablets of H. Karan Ukemarabi, Samsuluna, Amiditana, and Amisaduga. He announced the discovery of the name of Abishu on contemporary documents belonging to that reign. The two collections contain over 1,000 tablets. The Hay collection has 632 tablets, many of this epoch. Constantinople, in the Imperial Ottoman Museum at Constantinople, are a large number of tablets of this period. They are denoted by N, the Nippur collection, found by the American explorers there, S, the Sipar collection from the explorations conducted by Peter V. Scheil at Abu Haba, the T or Tello collection from the explorations of D. Sarzec. A few tablets are owned by Sir Henry Peake, Bart. A few tablets exist in the Fitzwilliam Museum at Cambridge. the gift of Mr. Bosanquet. A number of other tablets of the period are known to be in different museums or in the hands of private individuals. Publications. The historical value of the events used in dating these tablets was recognized by G. Smith, who published the dates of a number of the Loftus tablets in the 4th volume of the Cuneiform Inscriptions of Western Asia, p. 36. The earliest publication of the texts was by Peter J. N. Strassmayer in the Verhandlungen des Internationalen Orientalistischen Kongresses zu Berlin, 1881. In the Baelish he gave the lithographed text of 109 tablets under the title of Die Altbabylonischen Verträge Ausschwarka. He made many important observations upon their character and style, and gave a valuable list of words and names. As was to be expected from a first attempt, both his readings of the texts and his transcriptions from them leave room for some improvement. He arranged his texts according to the reigns of the kings mentioned. This edition formed the subject of M. V. Review's article, Une famille commère de Werka, and of numerous articles by other scholars in the journals. Dr. B. Meissner seems to have collated a number of these texts for his Beitrag zum Altbabylonischen Privatrecht. In 1888, Dr. T. G. Pinches published inscribed Babylonian tablets in the possession of Sir Henry Peake, Bart. It was followed by other parts and by Babylonian and Assyrian cylinder seals and signets in the possession of Sir Henry Peake, Bart. In 1890, these are most valuable for their full treatment. Photographs of the originals, drawings, and descriptions of the seals, transliterations, translations, and comments, giving a better idea of what these documents are like than can be obtained without actually handling the originals. Dr. Pinches, in his introduction, assigns their discovery to the ruins of Sippara. The texts published by him only include 3 from our period, 1, 1314, but nowhere will a beginner find more assistance in his studies of this class of tablet. In 1893, Dr. B. Meissner published his invaluable Beitrag zum Alt-Babylonischen Privatrecht, Void 11, of de Lietz and Haupt's Assyriologische Bibliothek. This gave a full transliteration and translation of 111 texts published in autography. Full notes and comments were added, giving practically all that could then be said on the subject. His introduction summarized the information to be extracted from his texts bearing on the social institutions of Babylonia. By arranging the texts in classes according to their purport and contents, he was able to elucidate each text by comparison with similar documents, and so to gain a very clear idea of the meaning of separate clauses, even when the exact shade of meaning of individual words remained obscure. Any advance which the interpretation of these documents may make must be based on his researches and follow his methods. He gave a useful glossary, but no list of proper names. In the 4th volume of Schrader's Kehlenschriftliche Bibliothek, 1896, Dr. F. E. Peiser adopted the plan of arranging the then-known contract texts in chronological order. He gave, in transliteration and translation, the texts of 31 tablets of this period. Of these, many had been previously published by Strassmayer and Meissner, but Dr. Peiser's renderings and short notes are of great value. In 1896 began the grand series of publications, cuneiform texts from Babylonian tablets, etc., in the British Museum, printed by order of the trustees, which has been continued to the present date. Volumes 2, pages 8 and 9, contain copies by Dr. T. G. Pinches of no fewer than 395 texts from the B1 and B2 collections. They also contain a number of letters and other texts, some of a date as late as Xerxes, but from the same 2 collections. In the Journal of the Royal Asiatic Society, 18,000, 971 and 1899, 1, Dr. T. G. Pinches gives transliterations, translations, and comments upon 15 of these texts. A word of notice must be given to the excellent guides published by the trustees of the British Museum, the Guide to the Koyunjik Gallery, with 4 autotype plates, 1885, and the Guide to the Nimrod Central Saloon are now superseded by the Guide to the Babylonian and Assyrian Antiquities with 34 plates, photographic reproductions of the originals, 1900. On pages 104-13 will be found a most useful account of the class of tablet and short descriptions of 94 exhibited case tablets. Most of these tablets have been published by Strassmayer or in cuneiform texts, but are now indicated by their new registration numbers. It will be evident from the above remarks that only a small proportion of the material in our museums has yet been published. It is greatly to be desired that every existing tablet should be published, as in no other way can we hope to solve many important problems. Not only the chronology, but much of the actual history can be recovered from these tablets, while the names of the witnesses and parties to the transactions will settle the order of the years, which are still doubtful. It is from these deeds that the greater part of this work will be constructed. They form the groundwork, while later documents fill in details. The chronological system, the years, were given names. Thus, the second year of HB Karen Rabi is called the year in which HB Karen Rabi, the king, established the heart of the land in righteousness. The year often received its name from the capture of some city. Are we to suppose that these events actually occurred on the first day of the year? If not, by what name was the year called up to the occurrence of the event in question? There is evidence that some years passed by two names, one of which was probably conferred after the year had begun. An examination of all dated tablets would doubtless result in fixing the time of the year at which the new year name came into use. This can only be achieved by the custodians of our great collections. But speaking generally, it seems obvious that names were often given to the years which attached to them a memory of the previous rather than a record for the current year. When in after years scribes drew up lists of the dates of a reign, they may well have made mistakes as to the exact year in which an event took place, and have also credited a king with too long a reign by counting as separate years two dates which were really the alternatives for one and the same year. In this way, we may perhaps account for the discrepancies between the chronicle and the king lists. Key to the order of events in a reign, the tablets often mention the name of the reigning king as well as the year name. Thus, we read as a date, the year when Samsaluna was king, followed by the year in which the canal of Samsaluna named PC Karen Sagalu was dug, which was the year name of Samsaluna's fourth year. Also, the parties often swore an oath to observe their contract by the name of one or more gods and of the reigning king. Hence, very often, when the date is not preserved at all, we know what reign was concerned. On the other hand, in some reigns we have dated tablets from almost every year. If all the tablets were published, the witnesses and other parties would enable us to fix the sequence of the years. As these year names each give a prominent event for the year, we could thus reconstruct a skeleton history of the reign. Indeed, the present writer had already determined the order of several years in more than one reign, from consideration of the persons named in each. Of course, no assurance could thus be had that some intermediate years were not omitted in such a scheme, since there is no certainty that we know the name dates for each year of a reign. The order of the kings themselves and the lengths of their reigns were already known from the king list published by Dr. T.G. Pinches. The Chronicle of the King, it seemed probable that the scribes of those days would have made lists of the year names in order to know how much time had elapsed since a given event had occurred. Hence, great was the excitement and delight when, in CT 6H, was published a tablet which once contained a list of year names from Sumuabu to Amizaduga. This was followed by the publication in Mr. L.H. King's Letters of H.B. Karen, Hammurabi of a duplicate, which served to restore and complete the list down to the 10th year of Amizaduga's reign. Mr. King further added the year names actually used on the dated tablets then published, thus showing how the year names of the list were quoted and either abbreviated or expanded. He very appropriately called this the Chronicle of the Kings of Babylon. In the meantime, Professor A.H. Sayce had given a translation of the first published list. In the fourth volume of the Beitrag zur Semischen Sprachwissenschaft, Dr. E. Lindell has given a full discussion of the first published list. He further adds a small list of the same character giving the year names in order for part of the reigns of Ak Karan Yuka, and Samsuluna. Dr. Lindell used the published dates of the contracts to complete and restore the first list. Thus, a great deal of excellent work has been done on these lists. None of them are complete for the whole dynasty, nor even for the part which they originally covered, and the known dated documents do not serve to fully restore them. But so far as they go, they must take the precedence of the king list, being almost contemporary documents. Other kings mentioned, besides the kings of the first dynasty of Babylon, the collections above referred to designate several other persons as kings. Thus, the B collection of the British Museum names Nur-adadi, Sin-Didinum, and Rim-Sin as kings. The texts enable us to fix all these as kings of Larsa. Hence, evidently the Tel Sifr, where these tablets were found, was in the territory of Larsa. The whole question is well discussed by the date on the tablet B34a refers to the setting up of a throne for Shamash by Nur-adadi. The date on B35 refers to the completion of a temple in Eridu by Sin-Didinum, king of Larsa. It is scarcely conceivable that these refer to other than the Nur-adadi, who set up the kingdom of Larsa in the south of Babylonia about the same time as Sumuabi founded the dynasty of Babylon. Sin-Didinum, his son, succeeded him as king of Larsa and claimed to be king of Shumer and Akkad. Elam, however, under Kuturnan-Hundi IS invaded the south, defeated Sin-Didinum, and set up Rim-Sin as king of Larsa. It seems that Rim-Sin reigned 37 years, partly as vassal of Hbkaren-Ukamarabi from the 17th year of Sin-Mubalit until the 31st of Hbkaren-Ukamarabi. Whether Sin-Didinum was then restored to his throne as vassal of Hbkaren-Ukamarabi, or whether Rim-Sin was succeeded by a second Sin-Didinum, or whether the restoration of Sin-Didinum after a temporary expulsion of Rim-Sin took place within the 37 years of the latter's reign, is not yet clear. Era of Isin. Of great interest is the fact of the use of an era in the south of Babylonia. A large number of tablets are dated by the years after the capture of Isin. Thus, tablets are dated in the 1st, 2nd, 3rd, 4th, 5th, 6th, 7th, 8th, 13th, 18th, 22nd, 23rd, and 26th, 27th, 28th, and 30th years after the capture of Isin. Most of them are related to the kingdom ruled by Rim-Sin, which clearly included Tel Sifr, and Nippur, Eridu, as well as Larsa. The first year of this era was probably the 17th year of Sin-Mubalit. Various historical identifications. A king, Emiru, is mentioned, usually alone, but once with Sumalalu, where the form of the oath, by Shamash and Emirum, by Marduk and Sumalalu, suggests that while Sumalalu was king of Babylon, the Marduk city, Emiru was king of a Shamash city. As he comes first, he was probably king of Sippara, where Shamash was the city god, and whence the collections B1, B2, and VV-A seem, on other grounds, to have come. That it was needful to name Sumulalilu also points to that king being overlord of Sippara at the time. The king Ilma-Elu, named in the oaths, associated with Shamash, may well be a vassal king of Sippara, though Professor Dalitz suggests that he may be the first king of the second dynasty of Babylon, whose name appears in the king list B as Ilma-Elu. The king Manibaltalel, on the Rev. J.G. Ward's tablet, seems to belong to the first or second dynasty, perhaps as a vassal king, but may have preceded them by some short period. The king Bankunaulu, mentioned by King, was associated with Sumulaulu. Probably he was vassal king of Sippara before Emiru. The third epoch, the Kassite kings. A number of extracts from the legal documents of the third period have been given by Father V. Shea in the Reçu de Travaux. The full text is rarely given, and there is consequently nothing for use here. They come from Nippur and are at Constantinople. The Semitic language is used largely, but a few Sumerian phrases remain. All the names of persons except those of the kings are pure Babylonian. The determinative of personality before proper names is common, but not before a king's name. The tablets are dated by regnal years, no longer by year. The kings have a determinative of divinity before their names. The money in use is either gold or bronze. Silver is hardly named, while in other epochs it is almost always used. Gold was now legal tender, as silver was afterwards. The many extremely fine charters of this period are of great value for the questions concerning land tenure. Descriptions and figures of some of them will be found in the guide. The text of several was published by Dr. C.W. Belser under the title Babylonische Kuduru Inschriften. Some of these are transliterated and translated in Schrader's Keelschriftliche Bibliothek, where references to the literature will be found. In many cases, these charters or boundary stones are the only monumental evidence for their period. They therefore figure largely in the histories. Some of the best examples are found in the second volume of the Memoirs de la Délégation, en Perse, beautifully reproduced by photogravure, admirably transliterated, and translated by Professor V. Scheil. Some fine examples are also to be found in cuneiform texts from Babylonian tablets, etc., in the British Museum. Of the time of Marduk Shumaddin, BC 853 to 833, we have a black boundary stone, published by Dr. F. E. Pieser in Keilschriftliche, Aktenstücke No. 1. It is dated in the 28th year of the reign of Nabu-Eplu-Iddina, circa BC 852. It rehearses the contents of 2 or more deeds by which a certain Kidanu came into possession of property in the city of Dilbat. The Cappadocian Tablets. The Cappadocian Tablets are still somewhat of a problem. The first notice of them was given by Dr. T. G. Pinches. According to the dealer's account, one acquired by the British Museum had come from Cappadocia. The script was then quite unfamiliar, and it was thought that they were written in a language neither Semitic nor Akkadian. Various attempts, which are best forgotten, were made to transcribe and translate them under complete misapprehension of the readings of the characters. But in 1891, Golonishev published 24 tablets of the same stamp, which he had acquired at Kayseri. His copies were splendidly done for one who could make out very little meaning, but he showed that many words were Assyrian and read many names. Professor Delitzk made a most valuable study of them and laid the foundation for their thorough understanding. Professor P. Jensen added greatly to our knowledge of their reading and interpretation. Dr. F. E. Pieser then gave a transcription and translation of 9 texts of contracts. They are now recognized to be purely Semitic. They must have been written in some place where Assyrian influence was all-powerful. There are many names compounded of Ashur. They are dated by eponyms as in Assyria. The discovery of many more of them at Boghaz Kiui, Karayuk, and elsewhere published by Professor V. Scheil in the Memoirs de la Mission en Cappadoce par Ernest Chantre, and commented on by M. Boisier, one make it certain that they are from this region. If subject to Assyria, their date may be before the earliest eponymist whose date is known from the canon lists. They may be contemporary with the very earliest kings of Assyria, but it is not impossible that the eponymists referred to were local only and not Assyrian in origin. Dr. Pieser put them after the first dynasty of Babylon, but before the third dynasty. They are full of unusual forms of words and have a phraseology of their own. They cannot as yet be translated with any confidence. In general, they are very similar to the contracts, money loans, and letters of the first dynasty of Babylon. As far as they can be understood, they offer no new features of interest. The obscure phrases and words give rise to many speculations which will be found in the above-mentioned works. These are of great interest, but need further data for elucidation. They are too questionable to be profitably embodied here. The Elamite contract tablets were found at Susa and are published by Professor V. Scheil in Tome 4 of the Memoirs Delegation in Persian. In external form, they closely resemble the Babylonian documents of a similar nature. They are drawn up in practically the same way, but there is a blunt directness about them which recalls the usages of the first dynasty of Babylon rather than Assyria or the Second Babylonian Empire. Hence, we have little to indicate date. Until we are better acquainted with the Elamite script at various periods, we cannot hope to date them. They have many peculiar words and phrases. Some may be Elamite, or that form of Semitic which obtained in Elam, but the rest of the language is ordinary Babylonian. It is possible that some characters had a value in Elam not known in Babylonia, or ideographic values not yet recognized, but, as a rule, the general sense is fairly clear. The fourth epoch, Assyria. The legal documents of Assyria are in many respects a separate group. They are sometimes said to have come from the library of Ashurbanipal, which Mr. H. Rassam claims to have discovered at Koyenjik in 1852-54. But it seems far more probable that as large numbers were already found by Layard in 1849-51, we have rather to do with the contents of some archives. The absence of any large number of temple accounts seems to exclude the probability that they were connected with a temple, But the fact that nearly every tablet has, for one principal party, some officer of the king, lends great probability to the view that the transactions were really made on behalf of the king, or, to be more exact, of the palace in Nineveh. The exceptions may be accounted for as really deeds concerned with former sales, or mortgages of property finally bought in for the king. The conjecture is raised to a moral, certainly by the contents of such a collection as Knudson's Gebete and den Sonnengod found together with them, which consisted of copies of the requests and inquiries made of the sun god oracle regarding the troubles and difficulties of the king and royal family, domestic as well as public, in the reigns of Esarhaddon and Ashurbanipal. The letters, too, found in the same collection, are the letters received by the king from his officers in all parts of his realm. The lists are connected with expenses of his household. Such votive tablets as are preserved are concerned with offerings of the royal family, or such high officers as probably were permanent inmates of the palace. We have, in fact, the contents of the muniment chests of the Sargonic kings of Assyria. That the royal library was mixed up with these documents may be due to the contents of an upper chamber falling when its floor was burnt out. But the mixing may have been done by the discoverers. In a very real sense, these come from a record office, but are confined to royal rather than state documents, though a few duplicates of charters occur. Hence, we look in vain for many classes of documents, such as are common in the archives of temples or private families. We have no marriage settlements, no adoptions, no partnerships. Can we believe that such transactions were less common in Nineveh than 15 centuries before in Sippara or Larsa or Babylon, or later in Babylon, Sippara or Nippur? There cannot be a shadow of doubt that such documents exist in shoals somewhere in the ruins of Nineveh and will one day be found. Hence we must regard it as extremely improbable that the ordinary citizens of Nineveh contributed the records of their transactions to the Koyunjik collections now in the British Museum. They either kept them in their own houses or in some temple archives. As will be seen later, a few have already been found, but it is extremely difficult to locate them exactly. It is quite certain that a few of the tablets in the British Museum were found at other localities, such as Sharif Khan, Ashur, Kala, Erech, Larsa, and Babylon. For the most part, these appear to have been placed in one collection by the discoverers, and only internal evidence can now decide where they were found. But the great bulk of the Koyunjik collections, as far as contracts, legal documents, and kindred tablets are concerned, are the result of explorations conducted on the site of the ancient Nineveh by Layard and Rassam. They probably came from palace archives, and as a result possess a special character of their own. Aramaic dockets. Aramaic dockets very early attracted the attention of Assyriologists. The presence of short inscriptions in Aramaic on a few contract tablets naturally raised hopes, in the early days of decipherment, of finding some check upon the reading of cuneiform. So far as these went, they were by no means inconsistent with the readings of the cuneiform, but they were too few, too disconnected, and in themselves too uncertain to be of great value. Indeed, for many of them, it is the cuneiform that now gives the key to their possible sense. The whole of these Aramaic inscriptions have now been published by Dr. J. H. Stevenson in his Assyrian and Babylonian Contracts with Aramaic reference notes, where references to the literature will be found. The collections of tablets. In connection with these Aramaic legends, a number of the texts of Assyrian contracts were published in the Corpus Inscriptionum Semiticarium par secunda Tomus IM. A number more were published in Vol. 3 of the Cuneiform Inscriptions of Western Asia by Sir H. C. Rawlinson. A few others were published in various journals, and by Opperts in his epoch-making treatise on the juristic literature, Documents Juridique, by Peiser in Vol. IV of Schrader's Kehlenschriftliche Bibliothek, and by Strassmayer in his Alphabetisches Verzeichnis. The whole of the texts of the Assyrian contracts from the Koyunjik collections in the British Museum are now published in Assyrian deeds and documents, recording the transfer of property, etc. 3 volumes published. A bibliography will be found there, on page 31. Their peculiar style, the very remarkable style which most of these tablets show, is so unlike the contemporary documents in Babylonia that we may expect that transactions between private citizens in Assyria at this time were quite different. A few such documents exist, Professor V. Shail, in the Recueil de Travaux, published the text of 4 which are quite unlike any of the Kuyungic examples. The plan of arrangement in the volume, in Assyrian deeds and documents, the same plan of arrangement was followed to some extent as in this work. Being all of one epoch and showing no signs of any development, the tablets were grouped provisionally according to subjects. The arrangement in each group was to place first the best specimens of the group and then the injured and fragmentary specimens, which thus received illustration and in some cases could be restored. It would, however, be an error to regard the Assyrian documents as the intermediate link between the Old and New Babylonian documents, though they belong chronologically to an interval which precedes the latter immediately. The Assyrian scribe used a formula that was closer to the Old Babylonian than to the contemporary Babylonian. It had an independent development, looking rather to the royal charters as models than to the private document. In fact, the closest parallels of all are to be found on the Babylonian boundary stones and charters. When, therefore, in our chronologically arranged sketch of a given subject, reference is made to Assyrian usage next to that of the first dynasty of Babylon, it will be understood that only the nature of the transaction is akin, and that, as a rule, the verbal treatment of it is quite distinct. Contemporary Babylonian documents. A few contemporary documents have reached us from the cities of Babylonia. They have little or no affinity with the immediately preceding groups, but carry on the local development from the second epoch. They come from many sites and are published in a variety of journals. A tentative list of them will be found in the appendix. They refer to transactions in the reigns of Shalmaneser IV, Sargon II, Merodach Baladan II, Sennacherib, Esarhaddon, Shamash Shumukin, Kundalanu, Ashurkati Lalani, and Sin-Sharish-Kun. In style, they belong to the next epoch. Fifth epoch, the Second Babylonian Empire. The Second Babylonian Empire, commencing with Nabopolassar and extending to the end of the independent existence of a Babylonian empire, is represented by thousands of tablets in our museums. A small part of these has been published. Peter J. N. Strassmeyer has given some 1,600 in his Babylonische Texte. Dr. Pizer published many more in his Kalenschrift. The Rebbe B. T. A. Ebbs, Dr. Moldenke, Dr. Pinches, and others have published many more. A detailed list will be found in the appendix. Persian Empire, and later, in the times of the Persian kings, very many documents were drawn up very similar to these. The series is quite unbroken down through Macedonian rule, the Arsacid period, to as late as BC 82. The list will be found in the appendix. Of the whole period, we may say that the variety and quantity of written evidence are amazing. Every sort of transaction that could be made the subject of a deed or memorandum was written down. They come from most of the chief cities in Babylonia. The classification of this material is no easy task. As in the case of the bibliography, so here, the first and apparently the only attempt has been made by Dr. C. Bezold in his invaluable Kurzverfasster Überblick. The view taken there depended upon Professor Oppert's estimate of the nature of the documents, and that again was often founded on imperfect copies of the text. A great advance has since been made in understanding the contents of the texts then published, and the number published has enormously increased. The publications, where accompanied by translations, have generally given some classification. Dr. Pizer, in the 4th volume of Schrader's Kielenschriftliche Bibliothek, gives most suggestive indexes. One Dr. Tallquist, in his Sprache der Kontrakte Nabunaids, gives a very valuable classification too. Druckmeisner classified his texts in Alt-Babylonische Privatrecht. A number of monographs have been written collecting the different texts from many sources bearing on one subject, thus acting as a kind of classification. A complete work on the subject is still needed. Monographs of great importance are Dr. F. E. Pizer's Jurisprudentiae Babylonicae quae supersunt, Cothen, 1890, Inog.dis, Dr. B. Meissner's De Servitut Babylonicae Assyriaca, Leipzig, 1882, Inog.dis, and Dr. V. Mark's De Stellung der Frauen in Babylonien, De Lubekadnesatio, APPB, published in the Beitragiser Assyriology, Vol. IV, pp. 177, These should certainly be read by any serious student of the times. To reproduce their contents would occupy too much space. On the whole subject of social life, as illustrated by these contracts, there is a valuable study by Dr. F.E. Peiser called Skiza der Babylonischen Gesellschaft 3 Professor Seises Babylonians and Assyrians in the Semitic series, 1900, is an excellent account, though in some respects not sufficiently critical. But in all such preliminary work, it is easy to feel sure of conclusions which have to be revised with fuller knowledge. Time will doubtless show this to be true of what is said in the present work, but wherever doubt is felt by the writer, it will be indicated.
Laws and contracts. The earliest Babylonian laws.
Nature of the oldest Babylonian laws. We are still completely in the dark as to the rise of law in Babylonia. As far back as we can trace the history or its written monuments, there is no time of which we can say, as yet there was no law. Our chief object today is to discover what the law was. For the most part, and until lately, we were compelled almost entirely to infer this from such contracts as were drawn up between parties and sworn to, witnessed, and sealed. Among them were a large number of legal decisions which recorded the ruling of some judicial functionary on points of law submitted to him. These, and the hints given by the legal phrase books, had allowed us to attain considerable knowledge of what was legal and right in ancient Babylonia or Assyria. Data hitherto uncertain, but the question remained, was it right or law? Were there enactments by authority making clear what was right, and in some cases creating right where there was none before? There was much to suggest the existence of enacted law, even of a code of laws, and the word law had been freely applied. But there was no known ascription of any law to a definite legislator. There was no word for law, only the terms judgments, right and wrong. It was significant that the parties to a suit always seemed to have agreed on what was right between man and man, and then to have sworn by their gods to observe the right. Evidence that there were very ancient codes. We definitely know of one great code of laws, that of H.B. Karen, U.C. Kamanabi. And we are greatly strengthened in the view that there were laws and even codes centuries before him. The way in which contracts quote the phrases of his code is exactly parallel to the way in which far earlier contracts quote phrases which are evidently extracts in the phrase books from some connected work. Hence, we are warranted in thinking that these extracts come from a Sumerian code of laws. We do not yet know to whom we should ascribe its compilation. Codes antecedent to that of H.B. Karen U. Hammurabi. For the code of H.B. Karen U. Hammurabi is also a compilation. He did not invent his laws. Phrases found in them appear in contracts before his time. Doubtless he did enact some fresh laws, but he built for the most part on other men's foundations. The decisions already passed by the judges had made men ready to accept as right what was now made law. But the question is only carried back a stage further. Did not those judges decide according to law? In some cases we know they did, for we have the law before them. When we try to penetrate further into the background of history, we can only surmise. Documents fail us to prove whether judges first made or administered the law. But we have now a very high antiquity for laws, recognized and obeyed as right. Sumerian laws found in the phrase books. That laws were already enacted in the pre-Semitic or Sumerian days, we may regard as certain. The legal phrase books drawn up by later scribes, especially those known as forming the series called Anaitisu, give as specimens certain laws. These were evidently given by the scribes as examples of connected prose in Sumerian, accompanied by a rendering into Semitic. Their object was primarily grammatical, or at any rate educational, but they are most valuable because they contain specimens of the Sumerian legislation. Owing to their limited scope, they were at first regarded as family laws, but there can be little doubt that they really are extracts from something like a code of laws. We are as yet quite ignorant of the date of their first promulgation, place of origin, and legislator. The seventh tablet of the series, Ana Itsu, Kol 33L, 22 to Kol 33L 22, gives the 7 following laws. Repudiation of father by son. If a son has said to his father, "You are not my father," he may brand him, lay fetters upon him, and sell him. It may be doubted whether this applies to any but adopted sons. "You shall not be my father" is a possible rendering, but the phrase may only refer to rebellious conduct. The word rendered brand has often been taken to mean shave. The cutting short of the hair was a mark of degradation. The Semitic Babylonians wore their hair long, while slaves, and perhaps also Sumerians as a race, are represented as hairless. However that may be, the same word is used of branding cattle, and it implies cutting or incision. It may mean a tattooed mark. The word rendered fetter seems also to be used of a branded body mark. The whole law means that the rebellious son is to be degraded to the status of a slave and treated as such. Repudiation of mother by son, i.e., if a son has said to his mother, "You are not my mother," one shall brand his forehead, drive him out of the city, and make him go out of the house. Here, the same ambiguity about branding is found. Some take the word rendered forehead to mean the hair of the head. His head would then be shaved. To go out from the house means to be cut off from kith and kin. But here the son retains his freedom, only he is in exile and homeless. In this case, it is not the mother who exacts the penalty. The verb is plural and may be taken impersonally. The family or the city magistrates are probably the ones to execute the law. Disinheritance of son by father I. If a father has said to his son, "You are not my son," he shall leave house and yard. Here the father has power to repudiate a son, who must go. The word for leave is literally take himself up, go up out of. The word yard is simply enclosure and may mean the city walls as a symbol of shelter. Disinheritance of son by mother IV. If a mother has said to her son, "You are not my son," he shall leave house and property. Here we expect, by analogy with laws I and I, that this penalty is rather less than that in 3I. The property means house furniture. The son must leave home and can take no house furniture with him. He has no claim to inherit anything, but he need not leave the city. Hence it seems likely that AWI denied him the right of city shelter. Repudiation of husband by wife. V. If a wife hates her husband and has said, "You are not my husband," one shall throw her into the river. Repudiation of wife by husband, VI. If a husband has said to his wife, "You are not my wife," he shall pay half a mina of silver. The contrast in the penalties is startling. Note the impersonal form of V. The executioners here are the family or city, not the husband. Publicity is therefore implied. It is not a private quarrel, but a refusal of conjugal rights. In the second case, the man divorces or puts away his wife, but pays a heavy fine. Responsibility of employer, VII. If a man has hired a slave and he dies, is lost, has fled, has been incapacitated, or has fallen sick, he shall measure out 10 kb datala of corn per diem as his wages. Here, the Sumerian text differs from the Semitic. In the former, the employer is said to cause the slave to suffer these detriments. In the latter, he is said to come by them. The verb rendered lost is used in that sense in the later code of HB Karen UK Marabi. What is the exact sense of the verb rendered has been incapacitated is not clear. Professor Hamel 1 renders der Brennen, Delitzsch renders weichen, entweichen, oder du Arbeit aufhören. But it is clear that the employer is to pay a daily fine for injury done to the slave or for loss to his owner, caused or connived at by him. The slave's refusal to work could not be made the ground for fining him. If anyone paid for that, it would be the owner. The employer pays for his work, but is bound to keep him safe and treat him reasonably well and return him in good condition to his owner. In later times, the owner often took the risk of death and flight, but then he probably charged more higher. At any rate, it is clear that the owner is not named in this law. It is not profitable to discuss these mere fragments of a code. The most interesting thing is their existence. We may one day recover the code in full. These are not retranslations into Sumerian by learned scribes of late laws, for exactly these words and phrases occur in the contracts of the first dynasty of Babylon, before and after the code of H. Karano Hammurabi, which deals with the same cases, but in different words. In fact, this Sumerian code is quoted, as the later code was quoted, in documents which embody the sworn agreement of the parties to observe the section of the code applying to their case. This is indeed the characteristic of the early contracts. After indicating the particulars of the case, an oath is added to the effect that the parties will abide by the law concerning it. Even where no reference is made to a law, it is because either no law had been promulgated on the point, or because the law was understood too well to need mention. Later, this law-abiding spirit was less in evidence, and the contract became a private undertaking to carry out mutual engagements. But even then it was assumed that a law existed which would hold the parties to the terms of an engagement voluntarily contracted.
The Code of Bangkam Karen Ukamarabi.
Witchcraft in the ordeal by water. If a man has accused another of laying a naratu, death spell, upon him, but has not proved it, he shall be put to death. If a man has accused another of laying a kispu upon him, but has not proved it, the accused shall go to the sacred river. He shall plunge into the sacred river, and if the sacred river shall conquer him, he that accused him shall take possession of his house. If the sacred river shall show his innocence and he is saved, his accuser shall be put to death. He that plunged into the sacred river shall appropriate the house of him that accused him. False witness in capital suit. If a man has borne false witness in a trial, or has not established the statement that he has made, if that case be a capital trial, that man shall be put to death. In civil case. If he has borne false witness in a civil law case, he shall pay the damages in that suit. Judgment once given not to be altered. If a judge has given a verdict, rendered a decision, granted a written judgment, and afterward has altered his judgment, that judge shall be prosecuted for altering the judgment he gave, and shall pay 12-fold the penalty laid down in that judgment. Further, he shall be publicly expelled from his judgment seat, and shall not return nor take his seat with the judges at a trial. Burglary and acceptance of stolen goods. If a man has stolen goods from a temple or house, he shall be put to death, and he that has received the stolen property from him shall be put to death. Dealings with irresponsible persons. If a man has bought or received on deposit from a minor or a slave, either silver, gold, male or female slave, ox, ass, or sheep, or anything else, except by consent of elders or power of attorney, he shall be put to death for theft. Theft. If a patrician has stolen ox, sheep, ass, pig, or ship, whether from a temple or a house, he shall pay 30-fold. If he be a plebeian, he shall return 10-fold. If the thief cannot pay, he shall be put to death. Procedure in case of the discovery of lost property. If a man has lost property and some of it be detected in the possession of another, and the holder has said, "A man sold it to me, I bought it in the presence of witnesses," and if the claimant has said, "I can bring witnesses who know it to be property lost by me," then the alleged buyer on his part shall produce the man who sold it to him and the witnesses before whom he bought it. The claimant shall on his part produce the witnesses who know it to be his lost property. The judge shall examine their pleas. The witnesses to the sale and the witnesses who identify the lost property shall state on oath what they know. Such a seller is the thief and shall be put to death. The owner of the lost property shall recover his lost property. The buyer shall recoup himself from the seller's estate. If the alleged buyer on his part has not produced the seller or the witnesses before whom the sale took place, but the owner of the lost property on his part has produced the witnesses who identify it as his, then the pretended buyer is the thief. He shall be put to death. The owner of the lost property shall take his lost property. If, on the other hand, the claimant of the lost property has not brought the witnesses that know his lost property, he has been guilty of slander. He has stirred up strife. He shall be put to death. If the seller has in the meantime died, the buyer shall take from his estate 5-fold the value sued for. Judgment by default. If a man has not his witnesses at hand, the judge shall set him a fixed time not exceeding 6 months. And if within 6 months he has not produced his witnesses, the man has lied. He shall bear the penalty of the suit. Kidnapping. If a man has stolen a child, he shall be put to death. Abduction of slave. If a man has induced either a male or female slave from the house of a patrician or plebeian to leave the city, he shall be put to death. Harboring a fugitive slave. If a man has harbored in his house a male or female slave from a patrician's or plebeian's house, and has not caused the fugitive to leave on the demand of the officer, over the slaves condemned to public forced labor, that householder shall be put to death. The capture of a fugitive slave. If a man has caught either a male or female runaway slave in the open field and has brought him back to his owner, the owner of the slave shall give him 2 shekels of silver. If such a slave will not name his owner, his captor shall bring him to the palace, where he shall be examined as to his past and returned to his owner. If the captor has secreted that slave in his house, and afterward that slave has been caught in his possession, he shall be put to death. If the slave has fled from the hands of his captor, the latter shall swear to the owner of the slave, and he shall be free from blame. Burglar. If a man is broken into a house, he shall be killed before the breach and buried there. Highway robbery. If a man has committed highway robbery and has been caught, that man shall be put to death. If the highwayman has not been caught, the man that has been robbed shall state on oath what he has lost, and the city or district governor in whose territory or district the robbery took place shall restore to him what he has lost. If a life has been lost, the city or district governor shall pay 1 mina of silver to the deceased's relatives. Theft at a fire. If a fire has broken out in a man's house, and one who has come to put it out has coveted the property of the householder and appropriated any of it, that man shall be cast into the self-same fire. Duties and privileges of an officer over the levy. If a levy master or warrant officer who has been detailed on the king's service has not gone, or has hired a substitute in his place, that levy master or warrant officer shall be put to death, and the hired substitute shall take his office. If a levy master or warrant officer has been assigned to garrison duty, and in his absence his field and garden have been given to another who has carried on his duty, when the absentee has returned and regained his city, his field and garden shall be given back to him, and he shall resume his duty. Rights and duties of his son. If a levy master or warrant officer has been assigned to garrison duty and has a son able to carry on his official duty, the field and garden shall be given to him, and he shall carry on his father's duty. If the son be a child and is not able to carry on his father's duty, 1/3 of the field and garden shall be given to his mother to educate him. Penalty for neglect of his benefice. If such an official has neglected the care of his field, garden, or house, and let them go to waste, and if another has taken his field, garden, or house in his absence, and carried on the duty for 3 years, if the absentee has returned and would cultivate his field, garden, or house, it shall not be given him. He who has taken it and carried on the duty connected with it shall continue to do so. If for 1 year only he has let things go to waste and he has returned, his field, garden, and house shall be given him, and he himself shall carry on his duty. As ransom, if captured. If such an official has been assigned to the king's service and captured by the enemy, and has been ransomed by a merchant and helped to regain his city, if he has had means in his house to pay his ransom, he himself shall do so. If he has not had means of his own, he shall be ransomed by the temple treasury. If there has not been means in the temple treasury of his city, the state will ransom him. His field, garden, or house shall not be given for his ransom. Duties of district governors. If either a governor or a prefect has appropriated to his own use the corvée, or has accepted and sent on the king's service a hired substitute in his place, that governor or prefect shall be put to death. Governors not to oppress subordinates. If either a governor or a prefect has appropriated the property of a levy master, has hired him out, has robbed him by high-handedness at a trial, has taken the salary which the king gave to him, that governor or prefect shall be put to death. The benefice of a levy master, warrant officer, or tributary inalienable. If a man has bought from a levy master the sheep or oxen which the king gave him, he shall lose his money. The field, garden, or house of a levy master, warrant officer, or tributary shall not be sold. If a man has bought field, garden, or house of a levy master, a warrant officer, or tributary, his title deed shall be destroyed and he shall lose his money. He shall return the field, garden, or house to its owner. Not to be bequeathed to his family, a levy master, warrant officer, or tributary shall not bequeath anything from the field, garden, or house of his benefice to his wife or daughter, nor shall he give it for his debt. From the field, garden, or house which he has bought and acquired, he shall make bequest to his wife or daughter, or shall assign for his debt. the obligation resting upon a buyer of real estate. A votary, merchant, or resident alien may sell his field, garden, or house, and the buyer shall discharge the public service connected with the field, garden, or house that he has bought. A benefice not to be exchanged. If a man has given property in exchange for the field, garden, or house of a levy master, warrant officer, or tributary, such an official shall return to his field, garden, or house, and he shall appropriate the property given in exchange. Responsibilities of land tenants. If a man has hired a field to cultivate and has caused no corn to grow on the field, he shall be held responsible for not doing the work on the field and shall pay an average rent. If he has not cultivated the field and has left it alone, he shall give to the owner of the field an average rent. And the field which he has neglected he shall break up with mattocks and plow it, and shall return it to the owner of the field. The rent of unbroken land. If a man has taken a piece of virgin soil to open up on a 3 years lease, but has left it alone, has not opened up the land, in the 4th year he shall break it up, hoe it and plow it, and shall return it to the owner of the field, and shall measure out 10 gur of corn for each gan of land. Loss of crop by storm apportioned between landlord and tenant. If a man has let his field to a farmer and has received his rent for the field, but afterward the field has been flooded by rain, or a storm has carried off the crop, the loss shall be the farmer's. If he has not received the rent of his field, whether he let it for a half or for a third of the crop, the farmer and the owner of the field shall share the corn that is left in the field according to their agreement. Landlord cannot restrain a satisfactory tenant from subletting. If a tenant farmer, because he did not start farming in the early part of the year, has sublet the field, the owner of the field shall not object. His field has been cultivated. At harvest time he shall take rent according to his agreement. Abatement of debt on account of storm, flood, or drought. If a man has incurred a debt, and a storm has flooded his field or carried away the crop, or the corn has not grown because of drought, in that year he shall not pay his creditor. Further, he shall post-date his bond, and shall not pay interest for that year. Rights in a crop pledge for debt. If a man has received money from a merchant and has given to the merchant a field planted with corn or sesame, and has said to him, "Cultivate the field and reap and take the corn or sesame that shall be grown," if the bailiff has reared corn or sesame in the field, at harvest time the owner of the field shall take what corn or sesame has been grown in the field, and shall pay corn to the merchant for his money that he took of him and its interest, and for the maintenance of the bailiff. If the field he gave was already cultivated, or the sesame was grown up, the owner of the field shall take the corn or sesame that has been grown in the field, and shall return the money and its interest to the merchant. If he has not money enough, he shall give to the merchant sesame, or corn, according to its market price, for the money which he took from the merchant, and its interest, according to the king's standard. If the bailiff has not reared corn or sesame in the field, the debtor's obligation shall not be lessened. The riparian responsibilities. If a man has neglected to strengthen his dike, and has not kept his dike strong, and a breach has broken out in his dike, and the waters have flooded the meadow, the man in whose dike the breach has broken out shall restore the corn he has caused to be lost. If he be not able to restore the corn, he and his goods shall be sold, and the owners of the meadow, whose corn the water has carried away, shall share the money. Penalty for neglect to shut off water. If a man has opened his runnel for watering and has left it open, and the water has flooded his neighbor's field, he shall pay him an average crop. If a man has let out the waters, and they flood the young plants in his neighbor's field, he shall measure out 10 gur of corn for each gan of land. Damage done to growing crop by sheep. If a shepherd has not agreed with the owner of the field to allow his sheep to eat off the green crop, and without consent of the owner has let his sheep feed off it, the owner of the field shall harvest his crop, but the shepherd who, without consent of the owner of the field, caused his sheep to eat it, shall give to the owner of the field, over and above his crop, 20 gur of corn for each gan of land. If, after the sheep have come up out of the meadows, and have passed into the common fold at the city gate, a shepherd has placed his sheep in a field, and caused his sheep to feed in the field, the shepherd shall keep the field he has grazed, and, at harvest time, he shall measure out to the owner 60 gur of corn for each gan of land. cutting down a tree without permission, rent of a garden plot. If a man without the consent of the owner has cut down a tree in an orchard, he shall weigh out half a mina of silver. If a man has given a field to a gardener to plant a garden, and the gardener has planted the garden, he shall train the garden 4 years. In the 5th year, the owner of the garden and the gardener shall share the garden equally. The owner of the garden shall gather his share and take it. If the gardener, in planting the garden, has not planted all, but has left a bare patch, he shall reckon the bare patch in his share. If he has not planted the field which was given him as a garden, then, if it was arable land, the gardener shall measure out to the owner of the field an average rent for the years that were neglected, and shall perform the stipulated work on the field, i.e., make it into a garden, and return it to the owner of the field. If the land was uncultivated, he shall do the stipulated work on the field, and return to the owner of the field, and shall measure out for each year 10 gur of corn for each gan. Garden rented on shares. If a man has given his garden to a gardener to farm, the gardener, as long as he holds the garden, shall give the owner of the garden 2/3 of the produce of the garden, and shall take 1/3 himself. If the gardener has not tilled the garden and has diminished the yield, the gardener shall pay an average rent. Here came the 5 erased columns, of which the 3 following sections are restored from copies in Ashurbanipal's library. Obligations of owner to gather a date crop assigned for debt, or if a man has borrowed money of a merchant and has given a date grove to the merchant and has said to him, "Take the dates that are in my grove for your money," that merchant shall not consent. The owner of the grove shall take the dates that are in the grove and shall answer to the merchant for the money and its interest, according to the tenor of his agreement, and the owner of the grove shall take the surplus of the dates that are in the grove. Eviction of house tenant. If a man has let a house, and the tenant has paid to the owner of the house the full rent for a term of years, and if the owner of the house has ordered the tenant to leave before his time is up, the owner of the house, because he has ordered his tenant to leave before his time is up, shall repay a proportionate amount from what the tenant has paid him. Acceptance of goods in payment of debt, in default of money or corn. If a man has borrowed money of a merchant, and has not corn or money wherewith to pay, but has goods, whatever is in his hands he shall give to the merchant before the elders. The merchant shall not object, he shall receive it. After the loss of about 35 sections, the code resumes. Responsibility of a traveling salesman. If an agent has received money of a merchant, he shall write down the amount and what is to be the interest of the money, and when his time is up, he shall settle with his merchant. If he has not had success on his travels, he shall return double what he received to the merchant. Robbery, substantiated by oath, a valid excuse. If the merchant has given money as a speculation to the agent, who during his travels has met with misfortune, he shall return the full sum to the merchant. If on his travels an enemy has forced him to give up some of the goods he was carrying, the agent shall specify the amount on oath and shall be acquitted. Responsibility to be indicated by legal receipts. If a merchant has given to an agent corn, wool, oil, or any sort of goods to traffic with, the agent shall write down the money value and shall return that to the merchant. The agent shall then take a sealed receipt for the money that he has given to the merchant. If the agent forgets and has not taken a sealed receipt for the money he gave to the merchant, money that has not been acknowledged by receipt shall not be put down in the accounts. Punishment of fraud of an agent. If an agent has taken money of a merchant and his principal suspects him, that principal shall prosecute his agent, put him on oath before the elders as to the money taken. The agent shall pay to the merchant threefold what he misappropriated. Fraud practiced by principal. If the principal has overcharged the agent and the agent has returned to his principal whatever his principal gave him, and if the principal has disputed what the agent has given him, that agent shall put his principal on oath before the elders, and the merchant, because he has defrauded the agent, shall pay to the agent sixfold what he misappropriated. Fraud in ordinary drink traffic. If the mistress of a beer shop has not received corn as the price of beer, or has demanded silver on an excessive scale, and has made the measure of beer less than the measure of corn, that beer seller shall be prosecuted and drowned. Conveyance at unlawful assemblages. If the mistress of a beer shop has assembled seditious slanderers in her house, and those seditious persons have not been captured and have not been haled to the palace, that beer seller shall be put to death. Drink traffic forbidden to votaries. If a votary, who is not living in the convent, open a beer shop or enter a beer shop for drink, that woman shall be put to death. Rate of payment with produce. If the mistress of a beer shop has given 60 kb dotitel yucca of Sakani beer in the time of thirst, at harvest she shall take 50 kb dotitel yucca of corn. Carrier's liability for misappropriation of goods. If a man staying abroad has given silver, gold, precious stones, or portable goods to another man to transport, and if that man has not delivered the consignment, where he has carried it, but has appropriated it, the owner of the consignment shall prosecute him, and the carrier shall give to the owner of the consignment fivefold whatever was entrusted to him. Unauthorized seizure of goods, denied a creditor. If a man has a debt of corn or money due from another, and without the consent of the owner of the corn has taken corn from the granary or barn, the owner of the corn shall prosecute him for taking the corn from the granary or barn without his consent, and the man shall return all the corn he took, and further lose whatever it was that he had lent. Punishment of vexations disjoint. If a man has no debt of corn or money due from a man on whom he has levied a disjoint, for each such disjoint he shall pay 1/3 of a mina of silver. Creditor responsible for fair treatment of a man held as security for debt. If a man has corn or money due from another man and has levied a distraint, and the hostage has died a natural death in the house of the creditor, he cannot be held responsible. If the hostage has died of blows or want in the house of the creditor, the owner of the hostage shall prosecute his creditor, and if the deceased were freeborn, the creditor's son shall be put to death. If a slave, the creditor shall pay 1/3 of a mina of silver. Further, he shall lose whatever it was that he lent. Limitations on the holding of such hostages. If a man owes a debt, and he has given his wife, his son, or his daughter as hostage for the money, or has handed someone over to work it off, the hostage shall do the work of the creditor's house, but in the 4th year he shall set them free. If a debtor has handed over a male or female slave to work off a debt, and the creditor proceeds to sell same, no one can complain. If a man owes a debt, and he has assigned a maid who has borne him children for the money, the owner of the maid shall repay the money which the merchant gave him and shall ransom his maid. Responsibility of owners of warehouses. If a man has deposited his corn for safekeeping in another's house, and it has suffered damage in the granary, or if the owner of the house has opened the store and taken the corn, or has disputed the amount of the corn that was stored in his house, the owner of the corn shall declare on oath the amount of his corn, and the owner of the house shall return him double. Rate of payment for storage of corn. If a man has stored corn in another man's house, he shall give, on each gur of corn, 5 kb do toital yucca of corn yearly as the rent for storage. Receipt for deposit of valuables. If a man has given another gold, silver, or any goods whatever on deposit, all that he gives shall he show to witnesses, and take a bond, and so give on deposit. If he has given on deposit without witnesses and bonds, and has been defrauded where he made his deposit, he has no claim to prosecute. Responsibility of bankers. If a man has given on deposit to another, before witnesses, gold, silver, or any goods whatever, and his claim has been contested, he shall prosecute that man, and shall return double what he disputed. Their own losses no excuse. If a man has given anything whatever on deposit, and, where he has made his deposit, something of his has been lost, together with something belonging to the owner of the house, either by housebreaking or a rebellion, the owner of the house who is in default shall make good all that has been given him on deposit, which he has lost, and shall return it to the owner of the goods. The owner of the house shall look after what he has lost and recover it from the thief. Depreciation of property. If a man has said that something of his is lost, which is not lost, or has alleged a depreciation, though nothing of his is lost, he shall estimate the depreciation on oath, and he shall pay double whatever he has claimed. Slander of votary or married woman. If a man has caused the finger to be pointed at a votary or a man's wife and has not justified himself, that man shall be brought before the judges and have his forehead branded. Marriage bonds. If a man has taken a wife and has not executed a marriage contract, that woman is not a wife. Punishment of flagrant adultery. If a man's wife be caught lying with another, they shall be strangled and cast into the water. If the wife's husband would save his wife, the king can save his servant. Rape of a betrothed virgin. If a man has ravished another's betrothed wife, who is a virgin, while still living in her father's house, and has been caught in the act, that man shall be put to death. The woman shall go free. The suspicion of adultery cleared by oath. If a man's wife has been accused by her husband and has not been caught lying with another, she shall swear her innocence and return to her house. Ordeal of water permissible to accused wife. If a man's wife has the finger pointed at her on account of another, but has not been caught lying with him, for her husband's sake she shall plunge into the sacred river. Rights and duties of the wives of those who have been taken captive in war. If a man has been taken captive and there was maintenance in his house, but his wife has left her house and entered into another man's house, because that woman has not preserved her body and has entered into the house of another, that woman shall be prosecuted and shall be drowned. If a man has been taken captive, but there was not maintenance in his house, and his wife has entered into the house of another, that woman has no blame. If a man has been taken captive, but there was no maintenance in his house for his wife, and she has entered into the house of another and has borne him children, if in the future her first husband shall return and regain his city, that woman shall return to her first husband, but the children shall follow their own father. Right of a deserted wife to remarry. If a man has left his city and fled, and after he has gone his wife has entered into the house of another, if the man return and sees his wife, the wife of the fugitive shall not return to her husband, because he hated his city and fled. Rights of a divorced woman who has borne children. If a man has determined to divorce a concubine who has borne him children, or a votary who has granted him children, he shall return to that woman her marriage proportion, and shall give her the usufruct of field, garden, and goods to bring up her children. After her children have grown up, out of whatever is given to her children, they shall give her one son's share, and the husband of her choice shall marry her. Rights of a divorced woman who is childless. If a man has divorced his wife, who has not borne him children, he shall pay over to her as much money as was given for her bride price, and the marriage portion which she brought from her father's house, and so shall divorce her. If there was no bride price, he shall give her 1 mina of silver, as a price of divorce. If he be a plebeian, he shall give her 1/3 of a mina of silver. Status of a worthless wife. If a man's wife living in her husband's house has persisted in going out, has acted the fool, has wasted her house, has belittled her husband, he shall prosecute her. If her husband has said, "I divorce her," she shall go her way, he shall give her nothing as her price of divorce. If her husband has said, "I will not divorce her," he may take another woman to wife. The wife shall live as a slave in her husband's house. The status of a wife who repudiates her husband. If a woman has hated her husband and has said, "You shall not possess me," her past shall be inquired into, as to what she lacks. If she has been discreet and has no vice, and her husband has gone out and has greatly belittled her, that woman has no blame. She shall take her marriage portion and go off to her father's house. If she has not been discreet, has gone out, ruined her house, belittled her husband, she shall be drowned. Marriage with a votary. If a man has married a votary, and that votary has given a maid to her husband, and so caused him to have children, and, if that man is inclined to marry a concubine, that man shall not be allowed to do so, he shall not marry a concubine. If a man has married a votary, and she has not granted him children, and he is determined to marry a concubine, that man shall marry the concubine and bring her into his house, but the concubine shall not place herself on an equality with the votary. A votary's rights against a maid assigned to her husband. If a man has married a votary, and she has given a maid to her husband, and the maid has borne children, and if afterward that maid has placed herself on an equality with her mistress, because she has borne children, her mistress shall not sell her. She shall place a slave mark upon her, and reckon her with the slave girls. If she has not borne children, her mistress shall sell her. Status of a wife afflicted with a disease. If a man has married a wife and a disease has seized her, if he is determined to marry a second wife, he shall marry her. He shall not divorce the wife whom the disease has seized. In the home they made together she shall dwell, and he shall maintain her as long as she lives. If that woman was not pleased to stay in her husband's house, he shall pay over to her the marriage portion which she brought from her father's house, and she shall go away. Wife's right to property deeded to her by her husband. If a man has presented field, garden, house, or goods to his wife, has granted her a deed of gift, her children after her husband's death shall not dispute her right. The mother shall leave it after her death to that one of her children whom she loves best. She shall not leave it to her kindred. Marital responsibility for antenuptial debts. If a woman who is living in a man's house has persuaded her husband to bind himself and grant her a deed to the effect that she shall not be held for debt by a creditor of her husband's, if that man had a debt upon him before he married that woman, his creditor shall not take his wife for it. Also, if that woman had a debt upon her before she entered that man's house, her creditor shall not take her husband for it. From the time that that woman entered into the man's house, they together shall be liable for all debts subsequently incurred. Evase at husband's murder by a wife. If a man's wife for the sake of another has caused her husband to be killed, that woman shall be impaled. Incest with own daughter. If a man has committed incest with his daughter, that man shall be banished from the city. Incest with daughter-in-law. If a man has betrothed a maiden to his son, and his son has known her, and afterward the man has lain in her bosom and been caught, that man shall be strangled, and she shall be cast into the water. If a man has betrothed a maiden to his son, and his son has not known her, and that man has lain in her bosom, he shall pay her 1/2 mina of silver, and shall pay over to her whatever she brought from her father's house, and the husband of her choice shall marry her. Incest with mother. If a man after his father's death has lain in the bosom of his mother, they shall both of them be burnt together. Incest with stepmother. If a man after his father's death be caught in the bosom of his stepmother who has borne children, that man shall be cut off from his father's house. Penalty for breach of promise. If a man who has presented a gift to the house of his prospective father-in-law and has given the bride price, has afterward looked upon another woman and has said to his father-in-law, "I will not marry your daughter," the father of the girl shall keep whatever he has brought as a present. Rights of a rejected suitor. If a man has presented a gift to the house of his prospective father-in-law and has given the bride price, but the father of the girl has said, "I will not give you my daughter," the father shall return double all that was presented him. Slandering rival not to profit by his calumny. If a man has brought a gift to the house of his prospective father-in-law and has given the bride crown and slandered him, and his father-in-law has said to the suitor, "You shall not marry my daughter," shall return double all that was presented him. Further, the comrade shall not marry the girl. Disposal of a wife's marriage proportion. If a man has married a wife and she has borne him children, and that woman has gone to her fate, her father shall lay no claim to her marriage proportion. Her marriage proportion is her children's only. If a man has married a wife and she has not borne him children, and that woman has gone to her fate, if his father-in-law has returned to him the bride price which that man brought into the house of his father-in-law, her husband shall have no claim on the marriage portion of that woman. Her marriage portion indeed belongs to her father's house. If the father-in-law has not returned the bride price, the husband shall deduct the amount of her bride price from her marriage portion and shall return her marriage portion to her father's house. Effect upon the inheritance of a father's gift to a favorite son. If a man has presented field, garden, or house to his son, the first in his eyes, and has written him a deed of gift, after the father has gone to his fate, when the brothers share, he shall keep the present his father gave him, and over and above shall share equally with them in the goods of his father's estate. Possession of a bride price for a young unmarried brother. If a man has taken wives for the other sons he had, but has not taken a wife for his young son, after the father has gone to his fate, when the brothers share, they shall set aside from the goods of their father's estate money as a bride price for their young brother, who has not married a wife, over and above his share, and they shall cause him to take a wife. Inheritance of children in case of 2 fruitful marriages. If a man has taken a wife and she has borne him children, and that woman has gone to her fate, and he has taken a second wife and she also has borne children, after the father has gone to his fate, the sons shall not share according to mothers, but each family shall take the marriage portion of its mother, and all shall share the goods of their father's estate equally. Disinheritance of a son. If a man has determined to disinherit his son, and has declared before the judge, I cut off my son, the judge shall inquire into the son's past, and if the son has not committed a grave misdemeanor, such as should cut him off from sonship, the father shall disinherit his son. If he has committed a grave crime against his father, which cuts off from sonship, for the first offense he shall pardon him. If he has committed a grave crime a second time, the father shall cut off his son from sonship. Status of children by a slave woman. If a man has had children born to him by his wife, and also by a maid, if the father in his lifetime has said, my sons, to the children whom his maid bore him, and has reckoned them with the sons of his wife, then, after the father has gone to his fate, the children of the wife and of the maid shall share equally. The children of the wife shall apportion the shares and make their own selections. And if the father in his lifetime has not said, my sons, to the children whom the maid bore him, after the father has gone to his fate, the children of the maid shall not share with the children of the wife in the goods of their father's house. The maid and her children, however, shall obtain their freedom. The children of the wife have no claim for service on the children of the maid. The rights of a widow in personal property. The wife shall take her marriage portion and any gift that her husband has given her, and for which he has written a deed of gift. And she shall dwell in her husband's house as long as she lives, she shall enjoy it, she shall not sell it. After her death, it is indeed her children's. If her husband has not given her a gift, her marriage proportion shall be given her in full, and from the goods of her husband's estate, she shall take a share equal to that of one son. Her rights in the home. If her children have persecuted her in order to have her leave the house, and the judge has inquired into her past and laid the blame on the children, that woman shall not leave her husband's house. If that woman has determined to leave, she shall relinquish to her children the gift her husband gave her. She shall take the marriage portion of her father's estate, and the husband of her choice may marry her. Dower rights of her children by second marriage. If that woman, where she has gone, has borne children to her later husband, after that woman has died, the children of both marriages shall share her marriage portion. If she has not borne children to her later husband, the children of her first husband shall take her marriage portion. Property rights of the children of slave father and free mother. If either a slave of a patrician or of a plebeian has married the daughter of a free man and she has borne children, the owner of the slave shall have no claim for service on the children of a free woman. And if a slave, either of a patrician or of a plebeian, has married a free woman, and when he married her she entered the slave's house with a marriage portion from her father's estate, be he slave of a patrician or of a plebeian, and from the time that they started to keep house, they have acquired property. After the slave, whether of a patrician or of a plebeian, has gone to his fate, the free woman shall take her marriage portion, and whatever her husband and she acquired since they started housekeeping, she shall divide it into 2 portions. The master of the slave shall take 1/2, the other half the free woman shall take for her children. If the free woman had no marriage proportion, whatever her husband and she acquired since they started housekeeping, he shall divide into 2 portions. The owner of the slave shall take 1/2, the other half the free woman shall take for her children. Property rights of the young children of a widow who remarries. If a widow, whose children are young, has determined to marry again, she shall not marry without consent of the judge. When she is allowed to remarry, the judge shall inquire as to what remains of the property of her former husband, and shall entrust the property of her former husband to that woman and her second husband. He shall give them an inventory, they shall watch over the property and bring up the children. Not a utensil shall they sell. A buyer of any utensil belonging to the widow's children shall lose his money and shall return the article to its owners. The property rights of a votary. If a female votary or vowed woman has had given her by her father a portion as for marriage, and he has written her a deed, and in the deed which he has written her he has not written that she may leave it as she pleases, and has not granted her all her desire, after her father has gone to his fate, her brothers shall take her field or garden, and according to the value of her share shall give her corn, oil, and wool, and shall content her heart. If they do not give her corn, oil, and wool, according to the value of her share, and do not satisfy her, she shall let her field and garden to a farmer whom she chooses, and the farmer shall support her. The field, garden, or whatever her father gave her, she shall enjoy as long as she lives. She shall not sell it, nor mortgage it. The reversion of her inheritance indeed belongs to her brothers, her right to convey property. If a female votary or vowed woman has had a portion given her by her father, and he has written her a deed, and in the deed that he has written her has declared that she may give it as she pleases, and has granted her all her desire, after her father has gone to his fate, she shall leave it as she pleases. Her brother shall make no claim against her. Her right of inheritance. If the father has not given a portion to his daughter, who is a female votary or vowed woman, after her father has gone to his fate, she shall share in the property of her father's house, like any other child. As long as she lives, she shall enjoy her share. After her, it indeed belongs to her brothers. Her proportion of her father's property. If a father has vowed his daughter to a god, as a temple maid or a virgin, and has given her no portion, after the father has gone to his fate, she shall share in the property of her father's estate, taking 1/3 of a child's share. She shall enjoy her share as long as she lives. After her, it belongs to her brothers. Additional privileges of votary of Marduk of Babylon. If a father has not given a portion as for marriage to his daughter, a votary of Marduk of Babylon, and has not written her a deed, after her father has gone to his fate, she shall share with her brothers from the goods of her father's estate, taking 1/3 of a child's share. She shall not be subject to duty. The votary of Marduk shall leave it after her to whom she pleases. Rights of a daughter by a concubine, if provided for by father on marriage. If a father has given a portion as for marriage to his daughter by a concubine, and has given her to a husband, and has written her a deed, after her father has gone to his fate, she shall not share in the goods of her father's house, if not so provided for by father. If a man has not given a portion as for marriage to his daughter by a concubine, and has not given her to a husband, after her father has gone to his fate, her brothers shall present her with a marriage portion, according to the wealth of her father's estate, and shall give her to a husband. Adoption of natural son. If a man has taken a young child, a natural son of his, to be his son and has brought him up, no one shall make a claim against that foster child. Adoption of child of living parents. If a man has taken a young child to be his son, and after he has taken him, the child discover his own parents, he shall return to his father's house. The son of a royal favorite, of one that stands in the palace, or the son of a votary shall not be reclaimed. Responsibilities of a craftsman to his adopted child. If a craftsman has taken a child to bring up and has taught him his handicraft, he shall not be reclaimed. If he has not taught him his handicraft, that foster child shall return to his father's house. Rights of inheritance of an adopted son. If a man has brought up the child, whom he has taken to be his son, but has not reckoned him with his sons, that foster child shall return to his father's house. Obligations on discarding an adopted son. If a man has brought up the child, whom he took to be his son, and then sets up a home, and after he has acquired children, decides to disinherit the foster child, that son shall not go his way. The father that brought him up shall give him 1/3 of a son's share in his goods, and he shall depart. He shall not give him field, garden, or house. Punishment for the repudiation of adoptive parents. If the son of a palace favorite or the son of a vowed woman has said to the father that brought him up, "You are not my father," or to the mother that brought him up, "You are not my mother," his tongue shall be cut out. If the son of a palace favorite or the son of a vowed woman has come to know his father's house and has hated his father that brought him up, or his mother that brought him up, and shall go off to his father's house, his eyes shall be torn out. penalty for substituting one infant for another. If a man has given his son to a wet nurse to suckle, and that son has died in the hands of the nurse, and the nurse, without consent of the child's father or mother, has nursed another child, they shall prosecute her, because she has nursed another child without consent of the father or mother. Her breasts shall be cut off. Assault on a father. If a son has struck his father, his hands shall be cut off. Graded penalties for assault and battery. If a man has knocked out the eye of a patrician, his eye shall be knocked out. If he has broken the limb of a patrician, his limb shall be broken. If he has knocked out the eye of a plebeian or has broken the limb of a plebeian, he shall pay 1 mina of silver. If he has knocked out the eye of a patrician's servant, or broken the limb of a patrician's servant, he shall pay half his value. If a patrician has knocked out the tooth of a man that is his equal, his tooth shall be knocked out. If he has knocked out the tooth of a plebeian, he shall pay 1/3 of a mina of silver. Brutal assault. If a man has smitten the privates of a man higher in rank than he shall be scourged with 60 blows of an ox-hide scourge in the assembly. If a man has smitten the privates of a patrician of his own rank, he shall pay 1 mina of silver. If a plebeian has smitten the privates of a plebeian, he shall pay 10 shekels of silver. If the slave of anyone has smitten the privates of a freeborn man, his ear shall be cut off. Fatal assault. If a man has struck another in a quarrel and caused him a permanent injury, that man shall swear, "I struck him without malice," and shall pay the doctor. If he has died of his blows, the sham shall swear and pay 1/2 a mina of silver, or, if the deceased was a plebeian, he shall pay 1/3 of a mina of silver. Assaults upon pregnant women. If a man has struck a free woman with child, and has caused her to miscarry, he shall pay 10 shekels for her miscarriage. If that woman die, his daughter shall be killed. If it be the daughter of a plebeian that has miscarried through his blows, he shall pay 5 shekels of silver. If that woman die, he shall pay 1/2 a mina of silver. If he has struck a man's maid and caused her to miscarry, he shall pay 2 shekels of silver. If that woman die, he shall pay 1/3 of a mina of silver. Narration of surgeon's fees. If a surgeon has operated with the bronze lancet on a patrician for a serious injury and has cured him, or has removed with a bronze lancet a cataract for a patrician and has cured his eye, he shall take 10 shekels of silver. If it be plebeian, he shall take 5 shekels of silver. If it be a man's slave, the owner of the slave shall give 2 shekels of silver to the surgeon. And penalties for unskillful operations. If a surgeon has operated with the bronze lancet on a patrician for a serious injury and has caused his death, or has removed a cataract for a patrician with the bronze lancet and has made him lose his eye, his hands shall be cut off. If the surgeon has treated a serious injury of a plebeian slave with the bronze lancet and has caused his death, he shall render slave for slave. If he has removed a cataract with the bronze lancet and made the slave lose his eye, he shall pay half his value. Cure of limb or bowel. If a surgeon has cured the limb of a patrician or has doctored a diseased bowel, the patient shall pay 5 shekels of silver to the surgeon. If he be a plebeian, he shall pay 3 shekels of silver. If he be a man's slave, the owner of the slave shall give 2 shekels of silver to the doctor. Fees for the treatment of the diseases of animals. If a veterinary surgeon has treated an ox or an ass for a severe injury and cured it, the owner of the ox or the ass shall pay the surgeon 1/6 of a shekel of silver as his fee. If he has treated an ox or an ass for a severe injury and caused it to die, he shall pay 1/4 of its value to the owner of the ox or the ass. Brander's liabilities. If a brander has cut out a mark on a slave without the consent of his owner, that brander shall have his hands cut off. If someone has deceived the brander and induced him to cut out a mark on a slave, that man shall be put to death and buried in his house. The brander shall swear, "I did not mark him knowingly," and shall go free. Builder's fee and liabilities for bad workmanship. If a builder has built a house for a man and finished it, he shall pay him a fee of 2 shekels of silver for each sar built on. If a builder has built a house for a man and has not made his work sound, and the house he built has fallen and caused the death of its owner, that builder shall be put to death. If it is the owner's son that is killed, the builder's son shall be put to death. If it is the slave of the owner that is killed, the builder shall give slave for slave to the owner of the house. If he has caused the loss of goods, he shall render back whatever he has destroyed. Moreover, because he did not make sound the house he built, and it fell, at his own cost he shall rebuild the house that fell. If a builder has built a house for a man and has not keyed his work, and the wall has fallen, that builder shall make that wall firm at his own expense. Boatmen's fees and liabilities. If a boatman has built a boat of 60 gur for a man, he shall pay him a fee of 2 shekels of silver. If a boatman has built a boat for a man, and has not made his work sound, and in that same year that boat is sent on a voyage and suffers damage, the boatman shall rebuild that boat, and, at his own expense, shall make it strong, or shall give a strong boat to the owner. Hire of boats. If a man has let his boat to a boatman, and the boatman has been careless and the boat has been sunk or lost, the boatman shall restore a boat to the owner. Responsibility of boatmen carrying goods. If a man has hired a boat and boatman, and loaded it with corn, wool, oil, or dates, or whatever it be, and the boatman has been careless and sunk the boat, or lost what is in it, the boatman shall restore the boat which he sank, and whatever he lost that was in it. If a boatman has sunk a man's boat, and has floated it again, he shall pay half its value in silver. If a man has hired a boatman, he shall pay him 6 gur of corn yearly. Law of collision. If a boat, on its course, has run into a boat at anchor and sunk it, the owner of the boat that was sunk shall estimate on oath whatever was lost in his boat, and the owner of the moving vessel which sank the boat at anchor shall make good his boat and what was lost in it. Working ox not to be distrained. If a man has levied a distraint on a working ox, he shall pay 1/3 of a mina of silver, hire of oxen and cows. If a man has hired a working ox for 1 year, its hire is 4 gur of corn. As the hire of a milch cow, one shall give 3 gur of corn to its owner. Liability for loss of ox or ass by accident. If a man has hired an ox or an ass, and a lion has killed it in the open field, the loss falls on its owner. Compensation for loss of ox by ill treatment. If a man has hired an ox and has caused its death by carelessness or blows, he shall restore ox for ox to the owner of the ox. If a man has hired an ox and has broken its leg or cut its neck, he shall restore ox for ox to the owner of the ox. If a man has hired an ox and knocked out its eye, he shall pay to the owner of the ox half its value. Responsibility for unavoidable accidents to a hired ox. If a man has hired an ox and has broken its horn, cut off its tail, or torn its muzzle, he shall pay 1/4 of its value. If a man has hired an ox, and God has struck it, and it has died, the man that hired the ox shall make affidavit and go free. Death by goring, accidental. If a bull has gone wild and gored a man and caused his death, there can be no suit against the owner. Responsibility for a vicious ox. If a man's ox be a gorer, and has revealed its evil propensity as a gorer, and he has not blunted its horn or shut up the ox, and then that ox has gored a free man and caused his death, the owner shall pay half a mina of silver. If it be a slave that has been killed, he shall pay 1/3 of a mina of silver. Responsibility of a tenant farmer. If a man has set another over his field, hired him, allotted him tools, and entrusted him with oxen for cultivating the field and provided harnesses for them, and if that man has appropriated the seed or provender, and they have been found in his possession, his hands shall be cut off. If he has taken the provender or rations and has enfeebled the oxen, he shall make it good from the corn he has hoed. If he has let out the man's oxen for hire, or stolen the seed corn, or has not produced a crop, that man shall be prosecuted, and he shall pay 60 gur of corn for each gant. If he is not able to pay his compensation, he shall be torn in pieces on that field by the oxen. Wages of laborers. If a man has hired a field laborer, he shall pay him 8 gur of corn yearly. If anyone has hired an ox herd, he shall pay him 6 gur of corn yearly. Theft of agricultural instruments. If a man has stolen a watering machinery from the meadow, he shall pay 5 shekels of silver to the owner of the watering machine. If a man has stolen a shaduf or a plow, he shall pay 3 shekels of silver. Wages of herdsmen. If a man has hired a herdsman to pasture oxen or sheep, he shall pay him 8 gur of corn yearly. Their liability. If a man has entrusted ox or ass to If he has lost the ox or ass given to him, he shall restore ox for ox and ass for ass to its owner. If a herdsman who has had oxen or sheep given to him to pasture has received his wages for the business and been satisfied, then diminish the herd or lessen the offspring, he shall give increase and produce according to the nature of his agreements. If a herdsman to whom oxen or sheep have been given has defaulted, has altered the price, or sold them, he shall be prosecuted, and shall restore oxen or sheep tenfold to their owner. If lightning has struck a fold, or a lion has made a slaughter, the herdsman shall purge himself by oath, and the owner of the fold shall bear the loss of the fold. If the herdsman has been careless, and a loss has occurred in the fold, the herdsman shall make good the loss in the fold. He shall repay the oxen or sheep to their owner. Hire of animals for threshing. If a man has hired an ox for threshing, its hire is 20 kebudatal yuka of corn. If he has hired an ass for threshing, its hire is 10 kebudoteluka of corn. If he has hired a young animal for threshing, its hire is 1 kebudotitle yuka of corn. Hire of wagon, oxen, and driver. If a man has hired oxen, a wagon, and its driver, he shall pay 160 kebed dotel yuka of corn daily. If a man has hired the wagon alone, he shall pay 40 kebiadotital yuka of corn daily. Graded wages of day laborers. If a man has hired a laborer from the beginning of the year to the 5th month, he shall pay 6 se of silver daily. From the 6th month to the close of the year, he shall pay 5 se of silver daily. Wages of artisans. If a man has hired an artisan, he shall pay as his daily wages, to a dot 5 c of silver, to a potter 5 c of silver, to a tailor 5 c of silver, to a stone cutter ce of silver, to a se of silver, to a carpenter 4 c of silver, to a carpenter 4 se of silver, to a rope maker 4 c of silver, to a sculptor up and up. Hires of various boats. If a man has hired a boat, its hire is 3 se of silver daily. If he has hired a fast boat, he shall pay 2.5 se daily. If a man has hired a ship of 60 gur, he shall pay 1/6 of a shekel of silver daily for its hire. Compensation for defect discovered in a slave after sale. If a man has bought a male or female slave and the slave has not fulfilled his month, but the Benu disease has fallen upon him, he shall return the slave to the seller, and the buyer shall take back the money he paid. If a man has bought a male or female slave and a claim has been raised, the seller shall answer the claim. Manumission of native slaves taken captive and bought back by traveling merchant of foreign slaves. If a man in a foreign land has bought a male or female slave of another, and if when he has come home the owner of the male or female slave has recognized his slave, and if the slave be a native of the land, he shall grant him his liberty without money. If the slave was a native of another country, the buyer shall declare on oath the amount of money he paid, and the owner of the slave shall repay the merchant what he paid and keep his slave. Punishment for repudiating a master. If a slave has said to his master, "You are not my master," he shall be brought to account as his slave, and his master shall cut off his ear.
The social organization of the ancient Babylonian state.
The 3 great classes of the population: the gentry, the common men, and the slaves. The state appears in the light of the Hbarn-UC Hammurabi Code to have been composed of 3 great classes: the Amalu, the Muskenu, and the Ardu. To the first class belonged the king and the chief officers of state, and also the landed proprietors. Their liabilities for fines and punishments were higher. Also in their case, the old law of eye for eye, tooth for tooth still held, while others came under a scale of compensations and damages. This may point to a racial difference. The ancient laws of Arabia may have been carried with them by Habias Kharon Hammurabi's tribal followers, while the older subject residents accepted the more commercial system of fines. The old pride of the Arab tribesman may have forbidden his taking money as payment for his damaged eye or tooth. But the Maskenu was more humble, as his name denotes, and may well have formed the bulk of the subject population. He was a free man, not a beggar. He was not without considerable means, as we see from the sections referring to theft from him. He had slaves, and seems to have been liable to conscription. His fees to a doctor or surgeon were less than those paid by an Amalu. He paid less to his wife for a divorce, and could assault another poor man more cheaply than could an Amalu. There can be no doubt that the Amalu was the gentleman or nobleman, and the Maskenu a common man or poor man. But the exact force of the terms is uncertain. In process of time, Amalu came to be used, like our Sir and even Esquire, of those who had no special qualifications for the title. Like the gentleman's gentleman of the servants' hall, he was only a respectable person. So even in the code, Amalu usually means no more than man. It already appears as a mere determinative of personality in the titles of laborers and artisans, when it cannot stamp them as landed proprietors. But it may mark them as members of the guilds of craftsmen, and recall the respect due to such. If, however, we press this, we must admit a guild of day laborers. There is no suggestion of any legal disability on the part of a Maskenu. He is merely a person of less consideration. Whether or not his ranks were recruited from the children of slaves by free parents is not clear, but it is very probable that they were. The slave was at his master's command, and like a child in his father's house, to some extent a chattel. He could be pledged for debt, as could a wife or child. He was subject to the levy, and his lot was so far unpleasant that we hear much of runaway slaves. It was penal to harbor a slave, or to keep one caught as a fugitive. Any injury done to him was paid for, and his master received the damages. But he was free to marry a free woman, and the children were free. So a slave girl was free on her master's death if she had borne him children, and the children were also free. He was subject to mutilation for assaulting a free man or repudiating his master, but his master had to pay for his cure if sick. He was not free to contract except by deed and bond, yet he and his free wife could acquire property, half of which would fall to his wife and children on his death. The levy master and the warrant officer, the code reveals the existence of a class of men, who were indeed known from the letters of H.B. Karen U. Hammurabi in the contemporary contracts, but whose functions are not easy to fix. They were the Rid Sabi and the Be'i Rub. By their etymology, these titles seem to mean slave driver and catcher, but the code sets them in a clearer light. They were closely connected, if not identical, officials. They had charge of the levy, the local quota for the army or for public works. Hence, levy master and warrant officer are suggestive renderings. For the former official, taskmaster, the one over the gang of forced laborers and reminiscent of the old-time press gang officers, is a fair translation. Field cornet would perhaps suit the military side. For some aspects of their office, the ancient reeve may be compared. Whether the catcher actually was a local policeman whose chief duty was to apprehend criminals and reluctant conscripts is not yet clear. The same name is used of fishermen who were catchers in another sense, and of hunters. A really satisfactory rendering is impossible, as we have now no officials whose duties actually correspond to theirs. Their compensation. Each of these officials held what may be called a benefice, or perhaps a fief. It consisted of land, house, and garden, certain sheep and cattle as stock, and a salary. It was directly ascribed to the king as benefactor. We may compare the Norman lords settled in England by the conqueror, or the Roman soldier colonists. The men may well have been the followers of the first founder of the dynasty. In a very similar way, the Chaldean conqueror Merodach Baladan Texant long after settled his Chaldean troops in Babylonia. We may regard these men as retainers of the king, and probably as originally foreigners. The benefice was held by them for personal service. They were to go on the king's errand when ordered. It was a penal offense to send a substitute. The errand might take them away from home and detain them a very long time. In such enforced absence, the official might delegate his son to take his place and carry on his duty. This implies that there was a local duty besides the personal service. Further, this needed a grown man to discharge it. The locum tenens enjoyed the benefice, with a reserve of 1/3 for the wife to bring up the children of the absent official. An official, by neglecting the care of his benefice, ran the risk of forfeiture. This came about by his absence giving the locum tenens opportunity to acquire a prescriptive right, which he might do in 3 years if he showed himself a more worthy holder. But this was only if the absentee had been neglectful, and a 1-year tenancy conferred no such right. The risks of public service. The service on which the official might be engaged was evidently military and had risks. It is not certain whether the Denatu 7 is really a fortress or a defeat. The word has both meanings. It does not really matter. Either way, the official is captured by the enemy of the king. He was bound to pay for his own ransom if he had the means, or if not, his town must ransom him, and failing that, the state. But he could not raise money on his benefice. Moreover, while it could descend to his son, it was inalienable. No diminution by bequest to his female relatives, no sale of part of it, no mortgage on it, nor even its exchange for other like estate was allowed. Further, the official and his benefice were protected. He could not be hired out by his superior officers, nor in any way plundered or oppressed. He held tax-free, subject only to his feudal duty. In some cases, the tributary there is associated with these two officials. The tributary, no duty is set down for him, beyond that implied in his name of paying a tribute. It is not clear that all land was held on one or the other scheme, but it is so in parts of the East still. Some land is held by personal service, some on payment of a tax. The tax later became the tithe. The personal service was later compounded for by furnishing a soldier or two for the army. The liability to serve in the levy continued to be borne by slaves and the lower classes, where we read that though a levy master, warrant officer, or tributary could alienate nothing of their holdings, other landowners could do so, but they did so subject to the buyer taking over the duty or service of the land so transferred. One of the classes here named, the votary, appears subject to service elsewhere. The votary of Marduk is expressly exempt from this service. The merchant, who represents another class, appears very often to have been a foreigner only temporarily resident in the country. The votary was already known to us from the contracts, but there was little to fix her functions. As seen in the code, she was a highly favored person, vowed to God, usually to Shamash at Sitpara, or Marduk at Babylon. There seems little to connect her with the prostitute votaries of Ishtar at Erech. She ordinarily lived in the convent or bride house of Shamash. She was given a portion, exactly like a bride, on taking her vow and becoming the bride of Shamash. But her property did not go to the convent. At her father's death, with her consent, her estate might be administered by her brothers, or she could farm it out. At any rate, she was provided for during her lifetime. But at her death, unless her father had specially given her power to bequeath it, her property went back to her family. She was not, however, doomed to spend all her days in the convent. She could leave it and even marry, but she was expected to maintain a high standard of respectability. For her to open a beer shop or even enter one for drink was punished by burning. She remained a virgin, even if married. She could have no children and must provide her husband with a maid if he wished to have a family. But she was carefully guarded from any reproach as childless. She ranks as a married woman, even if unmarried, and is protected from slander. Many noble ladies and even kings' daughters were votaries one. The merchant continually appears. Some passages suggest that he was a state official, the merchant. But this is really pressing too far the interest which the state took in him. He was doubtless, like the Jew of the Middle Ages, a valuable asset to the king. He seems to have been the usual moneylender, so much so that in many places merchant and creditor are interchangeable. A man is usually said to borrow of his merchant as we say of his banker. Doubtless, the king also borrowed from him. It is certain that the code was very lenient to him. But the merchant also did business in the way of ordinary trade. As a capitalist, he sent out his travelers and agents with goods far and wide, even into domains where the king's authority did not reach. Much of the code is occupied with regulating the relations between the merchant and his agent. The agency was that form of commenda which is so characteristic of the East at the present. The agent takes stock or money of his principal, signs for it, agrees to pay so much profit, and goes off to seek a market, making what profit he can. There is much to suggest that the merchant was not usually a Babylonian. In later times, the Arameans were the chief merchants and traveled all over Mesopotamia, Palestine, Syria, and into Asia Minor.
Judges, law coaches, and legal processes.
Antiquity of the judicial organization. Partly because specific references to judges and legal processes are not necessarily to be expected in historical inscriptions, and partly because we do not really know which are the earliest monuments of the race, it is impossible to decide when law courts first came into existence. It is generally admitted, however, that the stele of Manistusu is one of the earliest known monuments. There we read of Galzu, a judge. There also we find many of the officials who later acted as judges upon occasion. Hence it may fairly be said that judges were to be found in ancient Babylonia from time immemorial. They must have decided what was right when there was no written law to which to appeal. With the judges were associated as assessors the elders of the city. This was so marked a feature that in some cases we read that after hearing the complaint, the judge assembled the city to hear the case. In Babylonia, the maxim, litera scripta mane, was so well understood that hardly anything of importance was done without committing it to writing. Hence, we are as well informed about domestic affairs in Babylonia as about those of Europe in the Middle Ages. Sources of our knowledge of early legal procedure. It seems best to consider legal usages first, because they are essential to the understanding of all others. When we have a simple contract between two parties, we do not at once see where the reference to the law comes in. But the contract was not valid unless sealed and witnessed. The sealing was accompanied by an oath. The oath probably had to be made in court. The witnesses seem often to have been a body of men who could only be found at the court. Even when there is least trace of the law and the judge, the case is similar to others where the judge appears explicitly. It is also worthy of remark that, partly owing to our possession of the code and partly owing to the fuller nature of the legal decisions, we know far more of this subject, as of many others, in the early periods than in the later. Hence, the discussion of early legal usage is unusually full. When the evidence from later times merely supports this, it will not be noticed. Only divergences are worthy of record. As a rule, the procedure changes very little for many centuries. Judges, not often mentioned. The references to judges are less numerous than one would expect in the code, but it seems probable that the sentences there laid down had to be pronounced by the judge, if not carried out by him. We are, however, still in complete ignorance as to the machinery of police administration. We may argue from analogy in other countries and ages, but this is not a theoretical treatise on comparative sociology. We must content ourselves with direct evidence. Their very duties. Some sections deal explicitly with the duties of a judge. Thus, if a judge had given a judgment, decided the case, and embodied it in a legal decision, he was subjected to severe penalties for afterwards revoking his decision. If he had inflicted a penalty, he had now to repay it, 12-fold to him from whom it was exacted. Further, he was to be publicly deposed from his office, expelled from his seat of judgment, kusu dayanutisu, and no longer be permitted to sit with the judges. It is, of course, assumed that when he was called to account, he could not justify his former judgment, or else could not justify the change. But, as the law reads, it seems simply calculated to render a judgment once pronounced irrevocable, at any rate for that judge. Probably its revocation, in the case of injustice, was provided for by the right of appeal. He had to consider the words of the witnesses, amati sunu amaru, literally to see their words, perhaps implying that the depositions were written, but there are instances where amaru simply means to consider. 1. In a criminal case, where a man had to produce witnesses to save his life from a death sentence, the judge might grant him 6 months' grace in which to produce his witnesses. In later times, we have many examples of such a stay of process that evidence might be produced. Special directions to judges. Special directions are also given to a judge as to his procedure when a father was minded to disinherit his son, or when a widow with a young family wished to marry again. A slanderer was summoned before the judge. A son could not be cut off without referring the case to a judge. The children who wished to turn their widowed mother out of her house had to appear before a judge. Position, rank, and qualifications. For the most part, judges constituted a distinct profession, but it must not be understood that they had no other means of livelihood. Indeed, there is no hint anywhere that they received any remuneration for their services, but it was a high honor and by no means subsidiary to another office. Among those who officiated as judges, we find most of the higher officials. Doubtless the king himself acted as judge on occasions, and probably no great official of the realm was wholly free from the call to act in a judicial capacity. But as a rule, the judge is simply noted as judge. That the priests were judges is quite unproved. The judges were men of great importance and high rank, but there is nothing to show that they were priests. An age qualification is more likely. Method of appointment. The judge was a professional man. We often find a man bearing the title judge acting as party to a suit or witness to a deed, when he is certainly not acting in his judicial capacity. To a certain extent, he was a territorial officer, had his own district for jurisdiction, and was jealous of cases being taken elsewhere. How the ranks of the judges were filled, we do not know, but there is a hint of royal appointment in the phrase, the king's judges. On the other hand, there is clear evidence of the office being hereditary. Thus, Ibik Anutum had no less than 3 sons, Idin Ishtar, Marduk, Mushalim, and Nanar Idinum, all judges. Whether a right to the office descended in the female line is not quite clear, but we find a lady Ishtarumu among the judges on occasion. She was also the scribe 1. The chief justice, though many high officials acted as judges and so doing are named before the simple judge, there is no evidence of the existence of any chief judge. The order of names appears to be that of seniority alone. This may be due to the nature of our documents. The phrase books name a chief judge for Sumerian times. In the later Assyrian period, the chief justice was called Sartenu, evidently because he fixed the sartu, or fine, on the condemned party. Then also many high officials acted as judges. Scribes. The scribe exercised his craft as a profession. One often meets with a scribe, tapsaru, acting in a private capacity, as party to a suit or as witness. He retains the title even when the deed is drawn up by another writer. The class was very numerous. Almost every document is drawn up by a fresh scribe, so far as the scribe's name is recorded, for he often omits his title. Generally, he is the last of the witnesses, but not always so. Their duties. He wrote the whole of the document, including the names of the witnesses. There is no evidence that anyone else ever wrote a word on the document. As a rule, even when the names of the fathers of the witnesses are given, the scribe is content to write only his title after his name. Hence, we have no evidence whether the office was hereditary or not. Female scribes, women certainly were scribes. Out of a total of 90 names of scribes known, at least 10 were women. Here, a difficulty arises from the way in which women's names occur. At this period, proper names are usually written without the determinative which marks sex. Nor do the names decide, for both men and women bore the same name. Thus, Tarabatam is the name of 2 men and also of 2 women. Only when the title Tapsaru is given is the feminine determinative prefixed to that. We have, however, 10 clear examples. In the later times, the scribe usually was a man, but female scribes are known. One, the Aramaic scribe, is often named, also the Egyptian. The scribe usually held the agreement, which probably means that the parties were willing to leave it in his safekeeping. The scribe not a judge. The scribe was not a judge. It may be true that he sometimes acted as judge or became one, but then the higher office overshadowed the lower. He was no longer scribe but judge. A judge may sometimes have written down his legal decision and so acted as scribe, but we have no evidence of such a case. The judge seems never to have dispensed with the services of the scribe. The scribe was not a priest. There is no evidence whatever that either priests were all scribes or could all write, or that scribes were necessarily priests. The scribe not a priest, as a matter of fact, the same man may have acted both as scribe and priest. But the offices are distinct, and no one man ever bears both titles. That in later times the Amelu Rid, whose title can be read Sangwo, usually acts as scribe is due to the peculiar nature of the documents. These concern transactions in which the property of the temple or of its officials was in question. And one of the college of priests attached to that temple was charged with the duty of notary where temple interests were concerned. One might as well say that every clerk in the Middle Ages was a priest, because all the deeds of the monastery with which we were dealing were drawn up by Brother A, whose name was entered in some monastery list of the brethren as a priest. Whether the scribes were clerics and always attached to some temple in minor orders is not clear. On the whole, the evidence is against this conclusion. The witnesses. Witnesses. The word used to designate a witness is sibu, which denotes those who are gray-headed, but it is not certain that it can have no other meaning. It may mean those who are present. In actual use, we can distinguish three classes of persons to whom the term witness can be applied. The elders of a city. First we have the elders, the sibu, of a city. Possibly the karsipar, by which some men swore or in presence of which a contract was drawn up, were these elders of Sipar. They formed the pubkaranitaru, or assembly, in whose presence a man was scourged, from which a prevaricating judge was expelled. They may have been nominated or at least approved by the king, for we read of Sibe Sari. They were not exclusively men, for we have Sibeyu Sibatu. The recurrence of the same names at the same dates indicates that a body of official witnesses were held in readiness to act on such occasions. Many of them were temple officials or members of the guild of Shamash votaries. Their jury duties. Sometimes they are associated with the judges in such a way as to show that they were assessors. They included judges sometimes. At any rate, this witness is attached to a list of names which included a Nagiru of Babylon, a judge, and other high officials. In the time of Nur-Adadi, they sent a case before the king. They actually gave judgment. We may regard them as a jury, especially a grand jury, qualified by their own knowledge to understand the rights of the case and to judge of evidence. The judge gave the sentence. Trial witnesses. Secondly, we may distinguish the witnesses examined on oath. It is not clear that these were called by the same name. In the code we read of Sibi Moody, the witnesses that know, who seem to resemble very closely the Greek histories. These, of course, were usually not on the jury. They testified and were chosen by the parties to the suit, but the judge might examine persons who, in his opinion, would know. He selected and sent for them, directing the parties whom to produce. He might even adjourn the case for the production of witnesses. Witnesses to deeds. Thirdly, we may distinguish the witnesses to a document. Very often we can discern that these had an interest in the case. They might be relatives of the parties, neighbors of the estate in question, officials whose rights were concerned. In later times they received the special name of mukinu, the establishers. They may be presumed to have known at least the general purport of the deed which they witnessed. When the deed was called in question, they would be cited to state what they knew. In the case of legal decisions, both judges and jury occur as witnesses in this sense. Hence, in a great many cases, the distinctions drawn above do not hold. Whether the term Sibu was ever applied to the third class is doubtful. Their names are usually preceded by the sign which means before, however it was read. Settlements out of court. Cases of dispute settled out of court. When parties disagreed, they might discuss their difference between themselves and arrive at an agreement. Then they procured a scribe who embodied the agreement in a binding compact, Dupula Ragami. This took the form of a contract, the parties mutually undertaking not to withdraw from the agreement, reopen the dispute, or bring legal action one against the other. To give sanction to this agreement, they swore by the gods and the king. Witnesses were called upon to be cognizant of and attest the contract, and their names were added to the contract. To authenticate their names, both parties and witnesses often impressed their seals, or, in default of seals, made a nail mark. The date was then added. Each party seems to have taken a copy of the agreement, and the scribe held a third, or deposited it in the archives. Such cases may be said to have been settled out of court. At any rate, they contain no reference to a judge or court. But it is possible that the administration of the oath was a judicial, or perhaps a sacerdotal function. Further, the witnesses may have been drawn from a body of men held in readiness at court to perform that function. It is certain in some cases that agreements arrived at independently were taken to a judge for confirmation. 1 and the code expressly direct some cases to be taken to a judge, but it is probable that many cases were settled by mutual agreement. Recourse to a judge. When the intervention of a judge was deemed essential, one of the parties complained. The word really means to cry out, protest, but it is used in the freest way as equivalent to bringing the action. There is no evidence that anyone then submitted to wrong under protest. Whether the people were naturally litigious or simply because access to the courts was so easy, a protest usually involved a suit. The plea was made by the principals to the suit. There is no mention of an advocate or solicitor, but the verb generally used of the plea, ragamu, gives rise to targomanu, the original of the modern dragaman. He usually appears in later texts as the interpreter, but may originally have been the advocate. At any rate, in the bilingual days he might well have combined the offices. Another verb common at this period, pakaru, gave rise to pakiranu, later the usual word for plaintiff or claimant. The plaintiff in the reports here may be noted a peculiarity of the scribe's conception of the case. It will be found that, as he puts the case, the plaintiff generally loses. This is because the scribe will not prejudge the case by saying who was right. He writes, "Acclaim the property of B." In actual fact, it may have been that B laid claim to what he proved was his. But that excludes the scribe from saying that B claimed the property of A, because it never was A's. Hence, writing after the event, he ascribes the property to the rightful owner from the start of his document, and regards the wrongful holder as laying claim to it. Hence, we must not assume that the parties were not both claimants. In fact, both parties agreed, as a rule, so far as to submit their case to a judge. This is clear from the statements which follow the statement of the cause of dispute. Both parties went to the judges, or rather, quaintly, they captured a judge. The preliminary discussion between the parties resulted in agreement to submit the case to a judge. Both were willing to abide by the decision. Once, it is true, the plaintiff is said to have caught the defendant, won, but there is no evidence of unwillingness to submit. So too, when the parties are said to receive a judge, they evidently both sought him. Summons before the judge. Sometimes affairs did not go so smoothly. One party had to act and bring the other before the judges won or caused them to come before the judge. There are indications that the judges sometimes had to summon a party before them, or as the scribe puts it, bring him before the other party. This is also expressed by the judges sending up a party. Appeals there is considerable evidence that cases might be sent before the judges by a higher party, the king himself. These cases were probably on the suit of a plaintiff. In the letters of the First Dynasty, we have examples of the king sending to the local judges his own decision on the case, which they had to carry out. Or, in other cases, he simply sent the case for trial. Various places for holding a court. The parties, having found a judge and obtained a day for hearing, entered, or went down to, the great temple of Shamash at Sippara, called Ebabarim. There, as we know, Ebkaren Ukamarabi set up one of the copies of the code. The case was heard sometimes at the Old Gate. At Babylon, the parties were taken to the temple of Merodach Esagila. At Larsa, the gate of Nin Maruki, or the temple of Sin, might be chosen. The temple of Ishara is also named. Legal procedure. We have only scattered hints regarding legal procedure. The code says that the judges saw the pleas. The scribe uses the same expression. As a rule, he records the plaintiff's statement of claim first. Then he records a counterstatement. There is a strong suggestion that he quotes from written documents. The judges read these or heard the verbal statements. The deity, the theoretical source of all judicial authority, as part of the legal process, the object in dispute, or at any rate the deeds relating to it, were brought into court and resigned into the hands of the god. He was to discern the rightful owner and restore the object to him. Hence the decision was the judgment of Shamash in the house of Shamash, the judgment of the house of Shamash. So the defendant was said to make his account before Shamash. In bringing a suit, the parties sought the altar of Shamash. In case of loss or damage, the claimant recounted it before God. Summoning witnesses in confirmation of the statements alleged, witnesses might be called for who were put on oath before God and the king. They were supposed to know the object claimed and whose it was, or to know that a transaction had taken place. Bribing witnesses, tampering with witnesses, or with a jury was penalized by the code. The judges might refuse to accept the witness, and then might decide the case on the sworn deposition of the plaintiff. Different kinds of testimony, documentary evidence might be demanded. The judges might decide to take the evidence of their own senses and go to see an estate or a house in dispute 10, or they might determine that it was a case for the accused to purge himself, which he did by oath 11. Rendering the decision, having thus informed themselves of the rights of the case, the judges proceeded to pronounce a decision. They caused them to receive judgment. This phrase nearly always occurs in the legal decisions. The decision might be called the judgment of the particular judge, for example, Din Isarlim, Israel's judgment. The sentence is sometimes stated in the words of the judges themselves. Introduced by Iqbu, they said, 1. Thus we read, the tablet which A granted to B is good, they said. The collection of damages. If one party was in the wrong, the judges laid the wrong on him or put him in the wrong. When the suit was to recover a debt or find compensation, the judges might name a sum which they paid over to the proper person. 5. This was damages, not a fine. Picking a contract, table a ceremony, which often took place on the annulment of a former agreement, or canceling of a deed, was the breaking of the tablet embodying the former contract. The same ceremony took place on repayment of a debt or on dissolution of a partnership, apparently without recourse to judges. This was ordered by the code in case of purchases of property which it was illegal to sell or buy, such as the benefice of a reeve or runner. So when an adopted child had failed to carry out the bond to nourish and care for the adopted parent, the deed of adoption was formally broken by the judges. For later times, we have little evidence. What there is was collected by Kohlerpeiser and agrees in general with the above. The legal decision 6. The decision. In these ways, the judges quieted the strife, composed the complaint. It was the standard conception of a legal decision that it should be irrevocable. The code enacts the deprivation and deposition of a judge for revoking his judgment. The legal decisions lay down the stipulation that the losing party shall not turn back, shall not complain. These phrases nearly always occur, as they do also in contracts, to ensure compliance with the decision. The judges again exacted an oath. Whether both parties swore or only the losers is not clear. The statement usually is, they swore, without mention of the persons who did so. Documentary form. The decision being complete was embodied in a document drawn up by the scribe, regularly witnessed, often by the judges, and sealed. Thus it was that the judges granted him an irrevocable tablet of 1. These irrevocable tablets, practically imperishable also, have now come, after thousands of years, to tell their tale. Administration of oaths. Administration of the oath, the ceremony of swearing to the truth of evidence, or the terms of a compact, is continually mentioned. The exact form of words used in taking the oath is not certain, but in actual suits in the law court procedure, the judges administered an oath to both parties and witnesses. In the code, oaths were admitted for purgation of alleged crime as evidence of loss, deposit, injury, and the reception of a sworn deposition is recorded. References to oaths continually occur in the contracts. Form of the oath. The judges gave them to the oath before Shamash and Adad, or more briefly, gave him to the oath of God. The name of the god by whom men swore is usually given. As might be expected, the god who figured most prominently in the code was Shamash, the chief deity of Sibpara, often associated with his consort Ea or Malkatu. Sometimes the oath was by the king. Often one or more gods and the king are named together. When Babylon became supreme, it was usual to swear by Marduk and the local gods as well. The significance of these oaths for historical purposes is great, both as indicating political relationships and as often affording by the name of the king the only clue to the date of the document. Mr. King, in his edition of the Chronicle, won and died January 10, 1852, won and died Ode Barlow, won and died Ode Barlow, have made skillful use of these oaths in determining chronology. The place where it was administered. The administration of the oath took place before the censer of Shamash III or at the shrine, Sasaru, of Shamash IV in Sipara. or before the emblematic dragon sculptured on the doors of the Marduk temple at Babylon. 5. Other places are named which we are not yet able to identify. A kind of magical conjuration appears sometimes to have been employed, which is not yet understood. Its purport, the purport of the oath was not to give false evidence, or in the case of contracts, not to alter the stipulated agreements. It is often followed by the words, "Whoever shall alter or dispute the words of this tablet," evidently a quotation of the words of the oath, but the consequence of so doing is not given. Either it was too well known or too awful for the scribe to write it down. Its gradual decrease in importance. In Assyrian times, the oath did not play such an important part. Still, it was in use occasionally. The oath is generally found in documents of the grand style, such as royal charters. Oaths also are of interest for the pantheon of Assyria. A common way of expressing the same thing was to call on a god to be judge of the case, as for example, Shamash be judge, or Shamash be advocate, that is, take up the case. So, the king's son or crown prince is invoked to be the advocate. An appeal was also made to the decision of the king. The gods Ashur, Sin, Shamash, Bel, and Nabu, the gods of Assyria, shall require it at his hands, is another way of putting the case. These examples illustrate the meaning of the older oaths. There do not seem to be any cases of the witnesses being put on oath. But the oath lingered on into very late Babylonian times, when we have some very full forms. Its preservation as an antique form. If anyone shall change or alter the agreement, may Marduk and Zarpanit decree his destruction. 1. In Persian times we find a curse on the same breach of faith in the terms, "Whosoever shall attempt to alter this agreement, may Anu, Bel, and Ea curse him with a bitter curse. May Nabu, the scribe of Esagila, put a period to his future." It is curious thus to note a recrudescence of old forms in these later times. Was it merely an antiquarian fashion? Or had the Persians earlier come under strong Babylonian influence and preserved the old forms which had died out in their native home? The Elamite contracts suggest exactly the same question. In them, it seems evident that Elam, once under Babylonian influence, adopted and preserved under native rulers forms of which we have no trace in Babylonia, but which clearly came from that country. Assyria is another case in point. She kept forms which we know date back before the time of her independence and which had disappeared from the contemporary Babylonian documents. In the later Babylonian times, we still find the parties and the witnesses in a law court put to the oath. 3. Penalties for perjury. Penalties. An unsuccessful suitor was not allowed to get off merely with the loss of his suit. He had been put on his oath and been unable to justify himself or the word that he had spoken. According to the code, if the suit was a capital suit, this was punished with death. But even if the case was less serious, it was slander to have brought a false accusation, and the penalty for slander was branding. This penalty was inflicted on an unsuccessful suitor for possession of a house sold by his father. 6. Another form of penalty for unsuccessful litigation was that the suitor should not only lose his case, but actually be condemned to pay the penalty which he, if successful, would have brought on the other party. That this is what was really intended by the clauses is shown by the case of Bela-Litum, who, as late as BC 555, having brought a suit to recover a debt which she alleged was not paid, was convicted of perjury by the production of the receipt and by the evidence of her own children, and not only lost her case, but was condemned to pay the sum for which she had sued to him, from whom she sought to obtain it. This was, of course, a form of retaliation. Forfeits in Assyrian times, the parties usually bound themselves not to litigate, nor attempt to disturb the settlement made between them, under heavy forfeits to the treasury of a god, often tenfold the value of the object in dispute, and sometimes prohibitive in amount. Such sums as 2 talents of silver or 2 talents of gold controvert the idea that these forfeits were looked upon as possible deposits by a claimant desiring to reopen the case. They were terrific penalties intended to deter any attempt at litigation. Nature of the forfeits. The forfeits sometimes took the form of white horses or foals, which were dedicated to a divinity. Very interesting is the mention of the dedication of the eldest child to a god or goddess. This is worded as if the dedication was to be by fire. The additional mention of incense or cedar wood as accompanying the offering renders it probable that it was really meant that the litigant should be punished by the sacrifice of his child as a burnt offering to the god. But this only makes it clearer that such penalties were simply meant to be deterrent. We have no proof that such an offering ever took place. It was a memory of bygone horrors, but not less interesting as showing what had once been possible. A more natural and extremely common penalty was the payment of a tenfold value to the disturbed owner. In later times, this was 12-fold. This was an example of the multiple restitution so common in the code. The ordeal, something very like an ordeal, was occasionally imposed. The very fragmentary condition of the texts which give it adds to its obscurity. But it appears to have consisted in the litigant being compelled to eat a mina weight of some magically concocted food and to drink the contents of an inscribed bowl. What the result was expected to be is not stated. One fragmentary text appears to name the ingredients of the magic potion. All that can be made out points to an ordeal, somewhat similar to that inflicted upon a suspected wife in Numbers verse 12:31. Penalties for wrongdoing. We are chiefly indebted to the code for our knowledge of the penalties which the judge and his assessors might inflict. The death penalty. Foremost, we may place the death penalty. This was inflicted by the code for witchcraft, for theft, for corruption of justice, for rape, for causing death by assault, for neglect of duties by certain officials, for allowing a seditious assembly, for causing death by bad building, and for varieties of these crimes. It is curious that no mention is made of murder pure and simple. But this is only accidental. It is evidently assumed, for the code brings several cases of murder under this penalty. Procuring the death of a husband is punished by it, even a fatal assault, as that on a pregnant woman who dies of miscarriage as the result. The need of an oath to establish lack of malice in giving a blow in a quarrel which led to death tends to show that murder was punished by death, and that it was regarded as death intentionally caused. An explicit statement was clearly not needed. We do not yet know how this sentence was carried out. Usually the code only says he shall be killed. By whom or how is not stated. For special cases, the manner is described. Earning death by fire is directly ordered for a votary who opens or enters a beer shop, for a man and his mother in incest, and indirectly for a thief at a fire. Impalement. Impalement on a stake is ordered for a wife procuring her husband's death. Mutilations. The various sorts of mutilation named are of two types: retaliation for bodily disfigurement, symbolical of the offense itself. Thus, eye for eye, tooth for tooth, limb for limb are pure retaliations. But the hands cut off mark the sin of the hands in striking a father, in unlawful surgery, or in branding. The eye torn out was the punishing of unlawful curiosity. The ear cut off marked the sin of the organ of hearing and obedience. The tongue was cut out for the ingratitude evidenced in speech. Scourging. Scourging is the only other form of corporal punishment. It was done with an ox-hide scourge or thong, and 60 strokes were ordered to be publicly inflicted for a gross assault on a superior. Banishment. Banishment from the city was the penalty for incest. Simple restitution. Restitution may perhaps hardly be regarded as a penalty. Thus, a man who was found in possession of lost property had to restore it. In case of loss caused by neglect or ill treatment of hired property, or of goods deposited or entrusted, or by want of care in treating diseased limbs, restitution, goods for goods, ox for ox, ass for ass, etc., was ordered. Multiple restitution, but restitution of many times the damage inflicted is a distinct penalty. The code orders threefold for cheating a principal, fivefold for loss or theft of goods by carrier, sixfold for defrauding an agent, tenfold for theft by a poor man or for careless loss by shepherd or herdsman, 12-fold for a false sentence by a judge, 30-fold for theft on the part of a gentleman. Retaliation. The infliction of the same loss on a criminal that he caused another is seen in the cases of mutilation, eye for eye, limb for limb, tooth for tooth, but also in the penalty of son for son, daughter for daughter, slave for slave, and in the rule that a vexatious suitor shall pay the penalty which his suit was calculated to bring on the defendant. Vicarious punishment. This retaliation is the explanation of what seems to be vicarious punishment. where a man suffers in the person of his son or daughter for the loss he has caused to the son or daughter of another. Loss of claim. Another penalty was the voidance of a claim. If a man took the law into his own hands to repay his debt, he lost all claim to recover it through the courts. When the purchase was illegal and void, as that of an officer's benefice or of a ward's property, the purchaser had to return his purchase and lose what he had paid for it. Cases where no claim is allowed, in certain cases no suit was allowed to gain standing. Contributory negligence, the natural death of hostage for debt, the accidental goring of a man by a wild bull, are excluded from litigation. Such events cancel all further claim or are expressly said to have no remedy. There is no case for prosecution. Compensation. Compensation for loss caused by crime or neglect is ordered on a scale fixed by the code. Where a tenant takes a field on produce rent, his neglect to cultivate caused a loss to the landlord. He was thus bound to pay an average yield, or a crop like his neighbor's or that of the next field. In later times, the vagueness of this rule, which might give rise to dispute, was avoided by stating in the lease the average rent to be expected. For certain classes of land, where no comparison with the next field could be instituted, a fixed rate was set down. Compensation for premature ejectment was ordered.
Legal decisions.
Meaning of the term, by a legal decision. We understand a judgment pronounced by some judicial authority upon a case submitted. It is not easy to say whether the Babylonians had a separate name for this sort of transaction, but it had some peculiarities by which it can be easily recognized. It usually opens with the words dupu ana, tablet on, followed by the statement of the object in dispute. This is very often abbreviated to a simple ahan or asum anasum, concerning or eli with the same sense. These usages explain the curious tablet where we have a long series of sections, each containing names associated with other names by the word asum. Thus we read, Nishinshu, daughter of Rishsin, Asum Shamashelatsu, son of Itisin Denim. Technical terms used. It is not clear whether Shamashelatsu was the adversary of Nishinishu or the subject of her suit, but we clearly have here a trial list of 17 cases. Whether they were all decided in one day, month, or year, or whether they were reserved for the royal audience, we have no means of telling. It is merely a list. The object in dispute, 2 sar of land, is occasionally given, or the court is named the Temple of Shamash or at the Gate of Shamash. The whole text is too fragmentary to be translated, but we may note that some lady or other is always a party to the suit. If we could find the tablets referring to the decisions intended and they should turn out to be of different years, this list might prove of value for chronology. Their arrangement legal decisions relate to all manner of subjects and consequently are difficult to arrange. Dr. Meisner adopted the excellent plan of appending them to the groups concerned with the class of property dealt with under them. Thus, a legal decision concerned with the sale of a house would be grouped with the house sales. But this does not suit all cases, and both in formula and subject, the legal decisions are really distinct. Most legal decisions add nothing to our knowledge of the law, merely recording that A sued B and lost the day and is now bound over not to renew the litigation. A large number go only a little further, thus, 1. Sue concerning inheritance. Ribadam, daughter of Selah, was sued by the sons of Eribsin, Shuma Elu, and Maresitim, concerning what Selah her father and Malubtim her mother had left her. They took judges who restored to her 1/2 gan of land, her property. Shuma Elu and Maresitim, sons of Eribsin, shall not renounce this agreement nor dispute it. They swore by Shamash, Malkat, Marduk, and Sem-Sweluna, the king. 4 judges appear as witnesses, dated the 10th of Elul in the 2nd year of Samsuluna. Here it is not stated what was the ground on which the parties disagreed, nor that they laid claim to more than 1/2 gan of land. They lost the case. That is all we know in many other cases. Often we do not know the object in dispute. Other cases are quite full and often very instructive. Thus, 2. Suit for paternal power over daughter about the maid Ad Kalam, whom Aetia had left to her daughter H.B. Karen Ukulaltum. H.B. Karen Ukulaltum had taken care of her mother Aetia. while Sin Nasir, the husband of Ayatia, who was in Buzu for 20 years, had left Ayatia to her fate, loved her not. Now, after Ayatia was dead, Sin Nasir laid claim on whatever Ayatia had, and on HB Karen Ukulaltum for the maid Adkalam, Isharlim, the Rabianu of Sipar, with the Karsh Sipar, a signed sentence. They laid the blame on him. He shall not renounce the agreement, nor dispute it. They swore by Shemash, Marduk, and Pekaron, the Kemurabi the king, the judgment of Isharlim, 4 witnesses, dated in Elul, the 9th year of Pekaranuk, a Kemurabi. This was a bad case of desertion. The husband, Sin Nazir, deserted his wife for 20 years, but on her death came back and claimed her property. This he was not allowed to do by the code. In his absence, Ashya Karan Ukulaltum had cared for Ayatia, either as his real or only adopted daughter. In either case, Ashya had left Ashya Karan Ukulaltum a slave girl, Ad Kalim, whom Sin Nazir now claimed. His claim was disallowed. The decisions which we now possess give little further information as to the legal procedure, but a series of abstracts will illustrate the legal points which they raise. The suit on partnership Sili Istar and Omeeli, sons of Ilueriba, were sued by Erebum Sin, son of Ubar Sin, concerning a house, etc., which they bought of Sin Mubalit and his brothers. They say that they bought with money which Sili Istar received from his mother, and which formed no part of that which they had in common with plaintiff as partners. Deposition accepted, Karen Okamarabi. Sue for incomes. The sons of Zacia Su Sin Umgarani and Sin Uzili for rights in a house next the temple of Ningirsu, 5 days income in the temple of Sin, 16 days income in the shrine of Belit, and 8 days income in the shrine of Gula. Claim not made out. Era of Isin. No claim on property Idinadian and Matatum have no claim on property which HB Karen, Usish Hadam, has or shall inherit. Rimsin. Partnership Adadia Dinam and Ardi Martu agree on dissolution of partnership. Zabun. Inheritance brothers of Urilishu agree not to proceed against Sala Ilu and Urilishu concerning property left by latter. Apil Sin. Partnership family of Ura Gamal Su Arab Sin for account of his partnership with and his indebtedness to Ura Gamal deceased. Arab Sin settles. Gift Sinalatsu gave a ring to Reme Ishbakaronara. The children of Sinalatsu agree not to sue her for it. Bakarona Kamurabi. Settlement out of court, private settlement of claims to property. In the above cases, there is no explicit mention of judges. The next group are cases before judges where fact of suit, subject and result are given, but not the pleas presented. Property bought in Gursin and Ilu Ariba Su Ayatratum concerning a house which she bought of their father, non-suited, before judges of Babylon and Sipara. Partnership Sili Ishtar and Aribamsin entered into partnership. On dissolution of their partnership, they chose judges, paid in their common stock and shared equally. The shares are scheduled in the deed of settlement. HB Karen Ukam loss, Kamlarabi. Inheritance Paula, Shamash, and Apilitishu dispute concerning a division of property. They obtain judges and city witnesses. The whole house and income is shared equally and each agrees to waive further claim. HP Karen Ukemarabi. Inheritance, the 2 sons of Ku Ishtar disagreed as to their shares. Need not seen the Rab Martu makes equitable division. Pamina Mukama Asabi. Property Apil Ilshu and Palashamash dispute the latter's right to a house, ship, servants, money, and property in his possession. The city elders from HB Karanukut and Shababi gave judgment and confirmed the title of Pala Shamash. Inheritance, the sons of Nurshamash Su Belatum for the property left her, before judges, non-suited, Sumula Ilu. Income Shianuma Ili and Marsh Pitim Su Ribatum concerning her right to the legacy of Sala and Muluptim. The judges assign her an income, Etami Ilna, property Marduk Mubalit, and Sin Idinum Su Shad Malkat concerning her house in Bitgagim. Judges confirm her title, Apil Sin. Inkameshkarun Yukuzalam and Pai Malkat. Children of Nabi Shamash implead Shidi Lamazatan Chabkarunu of Gagim concerning various rights to incomes and rations in the temple of Shamash. The judges assign shares to each. Sam Suiluna. Property Eliku and Sumurame sue Shakumatim about a house they sold him. Non-suited. Property Shamash Balili repudiates a sale of land to the Lady Menaji. He is non-suited. HB Karen, UC Karen Wa, Kamrabi. Property family of Ardia Rabish against Arab Sin on account of property left them by Ardia Rabish. Non-suited. Sin Mubalit. Property HK Karen UC. Kamezaru sues Manutum for house and property, but is non-suited. Sumula Ilu. Vexatious prosecution. Kasha Upi bought a house of Idiotishu and his sons, Belshunu and Ilushubani. Amel Ninshuna, son of Belshunu, brought a suit about the house. Judges condemn him to be branded on the forehead and confirm Kasha Upi's title. Sin Mubalit. Land Nishinishu sues Anna Arishti Malkat for 3 sar of land before the king's judges. Non-suited Samsualuna. Land Malkat Kuzub Matim sues Ani Talame for restitution of a field before the judges of Babylon and Sippara. The witnesses sustain her claim, which is granted. Samsu. Iluna. Family dispute. The family of Isidaria sue the family of Azaliah about the property of Isidaria, deceased. Their title is confirmed. Zabum. How Shemash Belili sues Nidnusha concerning a house bought by him of her. The judges grant him 2 shekels of silver. HB Samuel Karen Ukamarabi. Lanchala Mazi sues her brothers for a field and wins her case. Change of venue before Lush Tamar, Nagiru of Babylon, Adadia Dinamin and Ibku Ishtar, judges. Zarakus was put to the oath and replied to Arib Sin. He was told that as his domicile was at Sippara, he must not make his appeal to the judges of Babylon, so his case was dismissed. Ibs Karon U Kamurabi. The record is defective. Cases before judges where the plea and its result can be made out with some certainty are as follows. A dispute about the title to Landardi Sin, son of Atiru, sued the sons of Shamash Nasir, who had sold a plot of land, 2.5 gan in area, to Ibni Adadi the merchant. He claimed the land as ancestral domain, Bit Abisu, and denied that he had ever alienated it. The sons of Ibni Adadi, now in possession, produced the deed of sale, Dupu Simati, which Atiru and Sin Nadin Shumi, his brother, had executed to Shamash Nasir and his son. The judges assigned a small portion of the land, about 1/6, to Ardi Sin, but make up the rest, apparently from another quarter, Amiza Duga. A title now invalidated by a revolution. Marmartu bought the garden of Sin Major. Ilubani disputed the legality, Sin Datu, of the sale. Before the judges at the gate of Ninmaki, he deposed that he was the adopted son of Sin Major, which adoption had never been revoked. In the time of Rim Sin, the house and garden had been awarded to Ilubani, and then Sin Mubalit had brought a suit against Ilubani, which was regularly heard before judges and witnesses from Ninmaki. They had awarded the house and garden to Ilubani. Sin Mubalit was now bound over to dispute the title no more. HB. Here it seems that on the deposition of Rim Sin by HB Karen UC Kamarabi, Sin Mubalit, excluded by his bond from disputing Ilubani's title, sold his claim to Marmartu, who attempted to enter into possession. Possibly it was thought that the new rulers would reverse the old decision. Right of a widow on remarriage to her husband's property or gifts. The sons of Namiatam sue their mother, Yashu Karonatam, about her share of their father's property. She appears before the judges of Babylon and puts in an inventory to show that she has taken nothing from the family possessions. Then the sons of Namiatam renounce further claim on the ground of family possession to the property of Idinadadi, Yashu Karonatam, and their descendant Samsui Luna. It seems that, after the death of Namiatam, Yashu Karonatam married again. The children of the first marriage bring an action to secure judgment that she shall not take with her any property of their fathers. She had, as we know, a right to take with her her marriage portion, but not her husband's gifts to her. Rantamel Ninsab Karan sues Garudu for the rent of a field. The debtor not paying was ejected, appeals Sin. Income Shumi Erstim sues for right to a sheep and some corn, the Naptanu of a god. Judges grant him half share. HB Karen, Ukam Kamarabi. Deposit judges summon Ibikiltim before Elalibani to account for corn. he purges himself on oath. Adoption Amat Shamesh claims to be the adopted daughter of Shamash Kamil and his wife Umi Arab Karantum. Her witnesses proving unsatisfactory, her claim was disallowed on the oath of Umi Arab Karantum that they had never adopted her. Ahmad Shameh Amakon. Loss of hired ass. Alushu Abushu hired a pack ass, Emer Bilti of Ardi Sin and Sili Ishtar, and lost it. The judges awarded them 16 shekels of silver as compensation. Apil Sin. Inheritance Babilitum sued Arish Sagil, Ubar Nabium, and Marduk Nasir for a share of her family possessions, Bit Abisa. The judges assigned her a share, Samsu Iluna. Forged will Nidnusha and Shamashabilu sue the daughter of Sinaribam about property which she claimed to have inherited. They charge her with having forged the will of Amti Shamash in her favor. The judges went to Gegim, where the property was, and examined witnesses who proved that Amti Shamash had left the property to the daughter of Sinaribam. The judges therefore confirmed her title. Legacy Marersatim left a female slave Damiktum to Arab Sin. His wife, Mazabatum, and his brother Ibni Shamish dispute this legacy. The judges inspect a document by which Arab Sin on the suit of Marersatim had granted Damiktum to Mazabatum and Ibni Shamish. The judges return Damiktum to Mazabatum. Eb Karon, Usur. Legal practice of Assyrian times. In Assyrian times, we have comparatively few legal decisions. The judges who appear are the Sartanu, or Chief Justice, the Chakuran Ailit Halazanu, the Chief Civil Magistrate of a city, the parallel of the ancient Rabianu, the Sukalu, or Chamberlain, and one or two others, besides the simple Dayanu, or Judge. Some of these are not judicial officers, but act in that capacity. Usually the judge is said to lay the blame on the guilty party, Arnam Eli Emedu, or to lay the penalty upon one, Sartu Eli Emedu. The sentence itself was a dianu, or judgment. As in former times, the legal decisions refer to all manner of cases, and here more than anywhere else, a mere translation does not convey much meaning to the reader. Theft of a bull thus one a scribe. A prosecuted a farmer, B, for the theft of a bull. They came before Nabuzarkenis Lashir, the deputy, H.B. Karen, Nidalezanu of Nineveh. Restitution, bull for bull, was imposed on the defendant, who meantime was held for the fine. On the day that he shall have made good the value of the bull, he shall go free, dated the 12th of Elul, eponemy of Mushalim Ashur. 12 witnesses. Theft of 4 slaves. Again, 2A stole 4 slaves of B, who summoned him before the Sukalu. The judge laid on him a fine of 210 minas of copper. B then deposited a pledge with A, either himself or a slave, to perform work equivalent to the amount of the debt. If B, or any representative of his, pays the money, the pledge is void. Whoever shall withdraw from this agreement, Ashur and Shamash shall be his judges. He shall pay 10 minas of silver and 10 minas of gold. He shall pay it in the treasury of Belit, dated the 10th of Adar, BC 678. 11 witnesses. Damages for loss by agent. Here is another case relating to a breach of trust. The decision of the Chief Justice, which he laid on H.B. Karen Okanai. 300 sheep with their belongings, property of the king's son, were lost or killed by the shepherds. Each shepherd was condemned to pay 2 talents of bronze as his fine. H.B. Karen Okanai and his people and his fields were taken as security for the payment for the 300 sheep, and the fines due from the shepherds. Whoever shall demand him, his Saknu, his Rabkisar, or any representative of his, shall pay for 300 sheep and the fines for the shepherds, and then Shbekaran Yukani shall be released. Dated 27th of Sebat BC 679, 4 witnesses. The defendant had been entrusted with 300 sheep, which he had to return in full with a proper increase of lambs. But, evidently in the disorders which arose on the death of Sennacherib, H.B. Karen Ukanai had lost or made away with them. If he had entrusted them to shepherds, either the shepherds had killed them, or, as some take it, H.B. Karen Ukanai had killed the shepherds. In the former case, he owed 2 talents of bronze as fine from each shepherd. In the latter, he had to pay the same amount for each. Either way, he was held responsible for the value of 300 sheep and 2 talents of bronze for each shepherd, He and all he had were seized for the liability. It is interesting to note that his district governor, or the colonel of the regiment to which he belonged, was thought likely to liberate him. But some other representative might do so. The lost property belonged to the king's son. This may have been Esarhaddon or one of Sennacherib's other sons. But, at any rate, it is clear that Esarhaddon was putting his household in order. Additional cases, the other examples known to us, do not add to our legal knowledge. The subjects are chiefly misappropriations of property, and there is little variety. Later Babylonian decisions. The later Babylonian tablets throw some light upon legal procedure in Babylon. The greater detail exhibited by them is due largely to the fact that for this period we have so many private documents. The greater portion of the material for this part of the subject has been worked over by Professor J. Kohler and Dr. F. E. Peiser. In their valuable treatise, Aus Babylonisches Rechtsleben, little can be added beyond additional examples and illustration. Method of procedure. The judges acted as a college and not separately. There might be present at a case a chief judge and several judges assisting. Other cases were decided before a single judge. The Sibutu continued to act as a jury. They were the elders of the city, competent to decide the rights of the case. But the exact form of the organization is not yet quite clear. The process began with the charge. The plaintiff preferred this himself, or by a messenger. His plea was heard and his proofs considered. Then, the court caused the accused to come before them and answer the charge. The possible complications. The process admitted of a third person intervening. Thus, A had pledged a plot of land to B for 32 shekels. Then he sold the property to C. C, dying, left the property to D, who wished to take possession from B, who continued to hold it in pledge. B goes to the judges and complains against D. A, being yet alive, intervenes and probably has to pay B. But the tablet being defective, we are not able to follow the case further. Only we see the sort of right which each had. Dispute for the possession of a sum of money. Another case is where two parties dispute as to the possession of a sum which is actually in the hands of a banker. The banker accordingly undertakes to produce the sum and its interest in court, and to pay it over to the successful party in the suit. The decision was written down, and the notary of the court gave a copy to the plaintiff, if not also to the defendant, and kept one copy for the archives. The plaintiff thus obtained a guarantee against the defendant. But how it was enforced, we have no evidence. Suit regarding loan on mortgage. The kind of points in dispute and decided are, as before, exceedingly varied. The decisions for the most part illustrate other subjects rather than the processes in court, but a few examples may be of interest. A made an advance of 44 shekels to B, who pledged a house for it. This state of affairs continued until both were dead. Their sons inherited. A's son demanded 44 shekels of B's son, who refused to pay. Both came before the judges. B's son pleaded that the money was never loaned or else repaid long ago. The judges demanded evidence. Either the contract or a receipt must be produced. The claimant was able to present the contract, but no receipt was produced. So the judges assigned the claimant a plot of land belonging to the defendant as satisfaction for the proved debt. Here we have the tablet witnessed by the chief judge, the judges, and the notary one. What is curious is that the claimant was not content to keep the pledge, but it is probable that the debt was secured on a house which the creditor did not take into his possession. It is also surprising that the judges did not order the house to be handed over to the claimant. That may have been avoided because of the family rights over the house. The debtor might thus have been rendered houseless or have lost his father's house. The widow may still have been an inmate. A great part of the document is taken up with the specification of the land handed over to the claimant. Hence, a complete translation is not given. Regarding possession of a slave, a common type of case was a vindication of right to some sort of property. Thus, A had sold B a slave, but C came forward and said, "He is my slave who fled from me," and took an oath by Bel and Nabu that he knew where that slave was living with A. The judges decide that C shall go where the slave is, and when he has proved that he is with A, the slave shall return to C. Acknowledgement of a debt. We have an acknowledgement before the court and a promise to pay the debt. This promise was usually made on oath, or guarantees were given. Here is an involved case. A is father of B's mother. B's father is long dead. The property of A, his grandfather, has now come into B's hands. He finds an old bond for an advance from A to C and D. The latter D is also dead, but had a son E who inherited. Hence, B now sues C and E for the money. The bond is shown to C, who remembers and acknowledges the debt, and he now undertakes to bring his fellow debuter E and discharge the debt. Settlement out of court. Men did not always stand their trial, but sometimes settled the case by an agreement out of court. A and his wife sued B for some slaves, people of their house. B dreads the trial and does not appear. The wife was B's mother, evidently remarried. B brings the slaves whom he still has and offers 4 minas as payment for one who has died in his house. The offer is accepted and parties agree to be quit. A private settlement, the decision of a dispute was not always referred to professional judges. A very interesting example occurs when the eldest member of the family and Kanati Aplisu, the family of his son, act as judges. The plaintiff is an old lady who had been married and had a daughter married. These facts are not rehearsed in the tablet itself, which concerns a division of property, but are collected from a number of tablets spread over some 60 years. The way in which information is thus collected is an instructive example of the manner in which the different documents illustrate and explain one another. Agreements to appear in court connected with legal decisions are the undertakings to appear before the court, of which we have several examples. Thus, A undertakes to bring B to Babylon and answer the complaint of C. Or again, a certain gardener spoke to A before an official of the Mar Banutu. This official was subpoenaed, as we should say, and swore by Bel, Nabu, and Darius that on the 8th of Sibat, 2 days hence, he would come and take up the case. Production of witnesses. The production of witnesses is the subject of not a few undertakings. Thus, by a fixed date, 5 days hence, A shall bring B to be questioned about some asses belonging to the royal household. Again, N swears to come 6 days hence and bring another on account of the witness about A. He further undertakes to establish the partnership. What was the exact cause of quarrel was not stated. These agreements to abide by the testimony of a named witness may have been entered into without reference to judges, but the oath may have been administered before the court. Thus, 2 parties agree to waive their dispute and abide by witness produced. This they do before the Atu official of the gate of the temple. Again, A is to bring witnesses on the 2nd of Ab to the door of the Tikalu's house and prove when and to whom he gave certain garments. If this be proved that B had received them, B will restore the said garments to A. If not, B is free. Further, if B does not appear on that day, he shall be bound to restore the garments. Several other examples illustrate the point. Production of bond, a common method, was, as has already been shown, to produce the bond or other document establishing the claim. If, for some reason, the document was not producible, the oath of the scribe who wrote it might be admitted. The witnesses whose names appear on the document do not seem to have been summoned, but in one case, when 2 Persians had sold 2 slave girls, also Persians, to a Babylonian, a 3rd Persian, who had been witness to the sale, was called on to swear, "I know that the money was paid," and he sealed the document.
Public right.
The mixed population of Babylonia. The early inhabitants of Babylonia are usually regarded as a non-Semitic race, whom we term Sumerians. Upon them was superimposed a layer of Semitic peoples. The first dynasty of Babylon is now often called Arabian, but the evidence of a previous admixture of peoples is not lacking. The subsequent history bears witness to many invasions by Kassites, Elamites, and nomad tribes, some Semitic, some probably not. Later came Persians and Medes, not to speak of Greeks and Parthians. Position and rights of resident aliens. The foreign wars brought slaves from all the surrounding countries, even as far away as Egypt. We cannot here enter into any discussion of the foreign elements in the population, but it is important to note what the attitude of the Babylonians was to the foreigners resident in their midst. The evidence on the whole is very slight. It may be said that as a rule, resident aliens became citizens and were under no disability. One section of the code, if we correctly understand it, allows an alien to purchase an estate, provided he bears the liabilities to the state, one which lay upon it. The merchant was probably usually an alien and only temporarily resident. In the contracts of the HB Karanu Hammurabi period, with the exception of the frequent Westamitic names, we have little trace of aliens. When the Kassites came, we may expect the conquering race to have had full right. In Assyria, there is no trace of disability. Egyptians, Elamites, Armenians, Jews, Arameans contract exactly like natives. In later Babylonian times, we find the same freedom. Of course, Persians, and later Greeks, were under no disabilities. Hence, there is very little at any time to chronicle under this head. We have marriages between Persians and Egyptians, with witnesses, Babylonian, Persian, Aramean, and Egyptian. Medes rent a Babylonian's house and live there. A Persian buys of a Babylonian. A Persian father gives Babylonian names to his children. A vivid picture of the mixed nationality in the time of Artaxerxes II is given in the business documents of Murashu's sons, and the list of proper names attached to Professor Hilprecht's edition sufficiently illustrates the point. Tax on landed property, ownership of land, carried its liabilities of tax or service. These were carefully guarded, and it was the mark of an oppressor to exceed the normal demand. That, however, seems to have been regularly and continually paid. A very good illustration of public rights over land, or the relation between the state and the private owner, is afforded by the construction, in the reign of Cyrus, of a canal of Shamash by the priest of Sippara. It was to pass through certain lands, and the consent of the owners had to be obtained. The magistrates and honorables of the city A, through which it would pass, and the peoples of the neighboring fields were assembled. They were asked to swear, as Susians, subjects of the king of Susa, that they would raise no difficulty. Then the priest took on himself the cost of the work on the canal, but stipulated that when it was completed, the neighbors should keep it in repair. Also, he forbade the construction of any rival canal. Riparians were responsible for the care of the canal, as shown in the code. State liabilities. The state undertook some duties. In the code we note that the palace would, failing other means, redeem an official from captivity. District liabilities. There were certain local liabilities of a public nature. Thus, the code shows that the magistrate and his district were held responsible for highway robbery or brigandage in their midst. It may be assumed that the funds to meet such liabilities were furnished by the city temple, for we note that if an official were captured and his private means were not sufficient for his ransom, his city temple had to furnish the money. General system of taxation. The whole question of taxation is full of difficulties. There were certain persons who paid tribute, that is, some proportionate part of their produce, others did personal service. There is frequent mention of dues of various sorts at ferries, marketplaces, and the like. Demands were made on the stock or crops of the farmers. But we are not yet in a position even to sketch the system of taxation.
Criminal law.
Reason for the lack of information regarding criminal law cases concerned with criminal law were naturally not embodied in contracts. Some cases doubtless may be inferred from the legal decisions, but these are only where the penalty had already been commuted from death or punishment to payment or restitution. They are better taken as examples of civil law. But this distinction is not the cause of their rarity or absence. When a man had to be put to death, scourged, or exiled, there was no need for a written bond. Hence, the only references which we have outside the code and the phrase books are the penalties set down in marriage contracts for conjugal infidelity, or for breach of contract voluntarily agreed to by the parties to it. Blood vengeance commuted for a gift. We have one case from Assyrian times of the assignment of a slave girl as composition for manslaughter. Atarkamu, a scribe, had caused the death of Samaku, whose son Shamashukin, Abkaroni, had the right to exact vengeance. Whether as the result of a legal decision or not, Atarkamu hands over a slave girl to Shamashukin Abkaroni, and they agree to be at peace. The name of Ashurbanipal occurs in a position which strongly suggests that the king himself sat in judgment upon the case. The tablet is so fragmentary that little else can be made out, but it seems to have been stipulated that the slave should be handed over at the grave. But what? Imprisonment. In later Babylonian times, we have a reference to imprisonment arising out of a case of guarantee 1. The priest of Shamash at Sippara had put A in prison in fetters. B, a fellow official of his of the same standing, bails him out, giving guarantee to the priests in Sibutu that A shall not go away, or if he does, that B will do his work. Assault. A case of assault and forcible entry into a house occurs. 2. but the tablet is so defective that we cannot make out the rights of the case. The superintendent of the city Shab-Karunrin in the 8th year of Cyrus complained to the priest of Shamash at Sippara to the following effect. He had taken into his house as a prisoner a certain man, A. He pleads that he is uncle to the priest and chief magistrate of the city. Why then has the priest raised his hand over him? Further, 7 men who are armed have burst in his door and entered his house and taken a mina of gold. Whether this was a rescue by relatives of the prisoner or by order of the priest does not appear. As a result of this complaint, the elders of the city were assembled and depositions made beyond the plea on the part of the housebreakers that someone had paid them to break in the door and that the prisoner A was someone's pledge. We get no further information. Tempting a slave to desert, a case of procuration of desertion forbidden by the code under pain of death, was condoned by the injured party. A caused a maid of B's to leave her master's house. B received her back, pardoned A, and took no money of him. Adultery and its punishment. Adultery was punished in the code by drowning. The code in this and similar cases of sexual irregularity is explicit that the case must be flagrant. Suspicion was not enough. 6. But conduct leading to scandal had to be atoned for by submission to the ordeal. The code did not take a higher ground than public opinion. The private contracts name death as punishment for adultery. Usually it is drowning, but being thrown from a high place, temple, tower, or pillar is named. In the later contracts, death was still the penalty for a wife's adultery, but the penalty had ceased to be drowning only. The adulteress might be put to the sword. A woman's procuring her husband's death for love of another was punished by impalement. The punishment of incest on the part of a man with his own daughter, involved his banishment. Incest with a daughter-in-law, if she was his son's full wife, was apparently punished by his being drowned. The code is obscure here, and we are not sure whether she was drowned also. If the girl was not yet fully married, the case was treated as one of ordinary seduction, and the culprit was fined half a mina. If a man committed incest with his own mother, both were burned. If a man had intercourse with his foster mother or stepmother, who had borne children to his father, he was disinherited.
The family organization.
The sources of information. Marriage is the bond which unites the different members of the family. The married pair, their children, slaves, and adjuncts, one side or the other, constitute the family unit. The Sumerian laws presuppose marriage, but, so far as known, merely attached penalties to repudiation of the wedded ties. The code is very full and explicit, and forms the basis of all our knowledge. The contemporary documents extend it in some particulars. In Assyrian times, we know little or nothing about the laws concerning marriage. In later Babylonian times, very little is known until the Persian period, when we have many illustrations. But what we know, or can gather from scattered hints, makes it clear that the state of things represented in the code remained practically unchanged for the whole period. The marriage contract and its obligations. The code is explicit that a woman was not a wife without bonds. This was a marriage contract, of which the essentials were that the names of the parties and their lineage were given, the proper consents obtained, and the declaration of the man that he has taken so-and-so to wife inserted. As a rule, stringent penalties are set down for a repudiation of the marriage tie. In these bonds, a man might be required to insert the clause that his wife was not to be held responsible for any debts he might have incurred before marriage. The code enacts that such a clause shall be held to act both ways. If it is inserted, then the man shall not be liable for his wife's debts before marriage. But if no such bond existed, the wedded pair were one body as far as liability for debt was concerned, by whichever it had been contracted, and, in spite of such a bond, both were liable together for all debts contracted after marriage. Family relations. The family relationship was of primary importance. Whatever may be said about traces of matriarchy in Babylonia, we have no legal documents which recognize the institution. The father is the head of the family and possesses full power over his wife and family. But the woman is not in that degraded condition in which marriage by capture or purchase left her. She was a man's inferior in some respects, but his helper and an honorable wife. Ancient Gentiles. Not only was the family, which consisted of the wedded pair and their dependents, a unit, But there was also a connection with ancestors and posterity, which enlarged the family to a clan or gens. In this sense, it often appears. The family thus constituted had definite rights over its members. It was very important to a man to be sure of his family connection. We may note the importance attached at all epochs to a man's genealogy. His family identified him. There was a very large number of well-marked and distinguished families which took their names from a remote ancestor. So far as our evidence goes, these ancestors were by no means mythical, but actually lived in the time of the first dynasty of Babylon. To all appearances, they date back to the conquest. Unfortunately, no attempt has yet been made to work out the family histories, but men of such families were the Marbane, or sons of ancestors, and had special privileges, which continually emerge into notice. We may compare the 100 families of China and the patricians of many nations. There were other families of scarcely less antiquity and consideration. They do not name their ancestor, but refer to him as a tradesman. They were sons of the baker, of the measurer, etc., with which we may compare our proper names Baker and Le Mesurier. There was a court of ancestry, bit Marbanity, which investigated questions arising from claims to belong to such families, and which doubtless preserved in its archives the genealogical lists of these exclusive families. They must have registered the birth of all fresh members and all adoptions, for men were adopted freely into such families. Guilds of workingmen. It is not clear whether all members of a family which traced descent, real or putative, from a trade father actually carried on that trade. If so, we should have examples of a workman's guild. Certainly many men who carried on a trade were sons of the trade father, but apparently not all. The code notes the adoption of a child by an artisan who teaches him his trade. In certain cities the trades had their quarters. We read of the city of the goldsmiths in Nineveh. Their rivals. It may well be that these guilds were close corporations at first, and continued so to be in the less crowded trades. But rivals outside the guild also came to be tolerated. The slaves were artisans in great numbers, and their increase may have led to the decay of the old artisan guilds of free workers. Public registration of family events. The importance of descent was not a sentimental matter only. The laws of inheritance involved a careful distinction between proper heirs and a variety of claimants. Hence, it seems likely that there was a registration of births, deaths, and marriages, at least covering the patrician families. We have such examples as a man claiming to be of the same father as another, claiming brotherhood. The other repudiates the claim. The tablet is too fragmentary for us to follow the arguments. The slave Bariki Ilu claimed to be a Marbanu, and his claim was heard before the court of the Marban. Entailed family property. Further, as the wife's marriage proportion, if she died childless, went back to the house of her father, and as a man who died without issue had to leave his property to his father's house, and as many had only a life interest in their property, while the family usually had a right of preemption in the case of proposed sales, we see that the family always had a strong hold over property. Not only was it for the man's interest to be registered as of a certain family, but it was also for the family's interest to register all its members. Responsibilities of family to its individual members. There are suggestions that the family assumed certain responsibilities over the man. For in Assyria, it appears that the family might come forward and liberate a man from his debt. A free man who had been sold as a slave to Ashnun and who escaped to Babylon after 5 years, being claimed as a slave by the levy masters there, chose to serve his father's house. His brothers swore by Marduk and Amiditana the king, making an irrevocable declaration that as long as he lived, he should take up the duties of his father's house with his brothers. In the later Babylonian times, the head of the family, though only a distant relation, was called upon to act as judge in a dispute concerning the disposition of property.
Courtship and marriage.
Amount of the bride price. The suitor came with presents to the parents of the girl. Most writers see in this a survival of the purchase of the bride. The name of this gift, Terb Karani Talatu, is undoubtedly connected with the name of the bride, Marb Karani Talatu. This present, or bride price, differed greatly with the circumstances of the parties. Both money and slaves were given, but a simple sum of money was more common. In cases where the bride was rich or highly placed, the amount seems less. A very usual amount was 10 shekels, but we have examples from 1 shekel up to 3 minas. The code assessed it at 1 mina of silver for a patrician and 1/3 of a mina for a plebeian. its disposal. Without this bride price, the young man could not take a wife. Hence, it was expressly secured to him by the code if his father died before he was of age to marry, and reserved as a first charge on the father's estate. There is some evidence that a woman might make this present to her future husband, but that may have been because he was too poor to make it himself, and she found him the means. As a rule, the parents gave this money to the bride, but we are not in a position to say whether they did so at once, on the consummation of the marriage, or on the birth of a child. The suggestion that it was her Morgengabe remains without support. Certain it is that it was not returned always. In the contracts, it seems to be given to the bridegroom with the bride. On a wife dying without children, the husband was bound to return her marriage portion to her family, but if the bride price which he had given for her had not been returned to him, he could deduct its value. On a divorce, he was bound to let his wife have not only her marriage portion, but the bride profs paid back to him. If there had been none, he must give her a fixed sum instead of it. Its presentation, from the phrase books, we may gather that there was a sort of ceremony about presenting the bride paste to the father. It was placed on a salver and brought in before the parents. This was probably a part of the ceremony of betrothal. If the father rejected the suitor, he was bound to return the bride price offered. A curious section of the code enacts that, if the suitor's comrade intrigued to break off the match, he was excluded from marrying the girl himself. Penalty for breach of promise. If, after he had brought in the bride price to his prospective father-in-law, the suitor took a fancy to another girl, he might withdraw from the suit, but he then forfeited what he had offered. If this really was the result of having taken a dislike to a plain girl, we may suppose that such a maiden might accumulate several bride prices and so acquire some wealth. This may explain Herodotus's idea that the handsome girls made a dowry for the plain one, but there is not a shred of evidence for their doing so in the way he suggests. A girl was a virgin when she was married. The preliminaries of marriage of interest in the later Babylonian texts is the fact that the preliminaries of the marriage are more fully illustrated. Thus, we read of the wedding of the daughter of Neriglissar. Nabu Shumukin, the Arab Biti of Nabu, judge of Ezida, spoke to the king Neriglissar, saying thus, "Give to me, Gigitum, your young daughter to wife." The tablet has only preserved a few lines from which we cannot be sure that the marriage took place. The tablet was called a duplicate of Ezida, showing that it was preserved in the Nabu temple at Borsippa. The following case is one of the clearest. Negotiation of a father for his son, Nabu Narkarin, son of Balab Karone Idin, grandson of Ardi Nergal, spoke thus to Shumukin, son of Mushalamu, saying, "Give me thy daughter in Asejel Banat, the maiden to wife, for Ubalitsugula, my son." Shumukin listened to him, and gave his maiden daughter in Asejel Banat to Ubalitsugula, his son. He gave also 1 mina of silver, 3 female slaves, named, and house furniture, with Ina Esagil Banat, his daughter, as a marriage portion to Nabu-Nadin-Ab Karoni. Nanakisharat, the maid of Shumukin, in lieu of 2/3 of a mina of silver, her full price, Shumukin gave to Nabu-Nadin-Ab Karoni out of the 1 mina of silver for her marriage portion. The deficiency, 1/3 of a mina of silver, Shumukin will give Nabu-Nadin-Ab Karoni, and then her marriage portion is paid. Each took a writing. Here the father negotiates for his son. There is no evidence of any bride price being paid, but the examples of this kind of document are too few for us to establish any fixed conclusions. In the following case, something very like it appears. Negotiation with a mother for her daughter, Dagilalani, son of Zambubu, spoke thus to H.B. Karen Ukama, daughter of Nigal Idin, son of Babutu, saying, "Give me thy daughter, Ladubashini, she shall be my wife." H.B. Karen Ukama listened to him and gave him her daughter, Ladubashini, to wife, and Dagilalani, in the joy of his heart, gave to H.B. Karen Ukama for Ladubashini, her daughter Anna Eli Beli Amur, a maid, for 1/2 a mina of silver, and 1.5 mina of silver to boot. The day that Dagilani shall take a second wife, Dagilani shall give Latubashini 1 mina of silver, and she shall go back where she was before, with the cognizance of Shumadin, son of Inaishiter, son of Sindamaku. Here the man himself negotiates. The mother gives the bride. Whether he really buys her is hard to say. The mother may have adopted the girl to care for her old age, as was often done. The bridegroom may have compensated the mother with means to adopt another daughter. What locus standi Shumadin had is not clear. He may have been the real father of the bride and so had to be satisfied that she was fairly treated by the change in her position, or his consent to the bridegroom's alliance may have been needed. The penalty set down for divorce is not high and the bride was probably poor. We see she was portionless. In other cases it was as high as 6 minas of silver. Occasionally the deed of marriage also named a penalty for adultery on the part of the wife. Role of the contracting parties, women were given in marriage. The suitor for her hand did not perhaps see her until marriage, but this is not likely, since he is contemplated by the code as capable of having cast his eyes upon another, and so, desiring to retreat from his suit, at any rate he brought presents to her father, who accepted or rejected him. There is no hint that the woman had any choice. The result of this power over the child's marriage was that conditions might be imposed on the marriage. The bride might be required to do service to an existing wife or to the bridegroom's mother. Further, the disposal of property was not entirely free after marriage. It depended upon what the father had laid down in the marriage settlement on his daughter. It was strictly limited to the woman's children, and if there were none, it went back to her father's house. Giving away the bride. In early times, the father usually gives the bride, but in a great many cases, this duty fell on the mother. How this came about, we do not usually know. The father being dead or the girl illegitimate seem the best explanations as a rule. In the absence of father and mother, the brother as head of the family assumed the duty. The examples of this are common enough. For later times also the examples are numerous of the power of agnates to give in marriage. It may perhaps be deduced that the children in these cases were young. Widows free to dispose of themselves. Women once married were free to marry again of their own choice, whether divorced, separated, or widowed. A betrothed girl or bride, if her marriage were not yet consummated, being seduced by her father-in-law, in whose house she had gone to live, was also free to marry. But it does not seem that women who were yet virgins could choose their own husbands. Even princesses were given in marriage. Consent of bridegroom's father or guardian requisite for a legal marriage. The man was not altogether free to marry. The code contemplates a boy left by the death of his father too young to marry. The brothers, when they divided the father's property, were bound to set aside for him, in addition to his share of his father's property, a sum for a bride price, and take him a wife. It seems probable that men married while still young and living at home, for the code contemplates the bride being brought to live in her father-in-law's house. In later Babylonian times, at any rate, the son could not marry without his father's consent. This we learn from a suit in high life in the time of Cyrus. A high official of the kings, A, brought a suit against B, who was over the house, before the nobles and the king's judges. A accused B and C, an official of his house, of having given a tablet of marriage contract of D, a sister of C's, to A's son without A's consent. Put to the oath, B swore that he did not seal the tablet. Then D was questioned. Then C acknowledged that he had drawn up and sealed with B's seal the marriage contract of D to A's son. The judges ordered D to return to her brother's house. The tablet was to be broken whenever found. If afterward D should be seen with A's son, she was to bear the sign of a concubine. The court of registration. From other examples, the conclusion is inevitable that, if a woman desired to be a full and proper wife, she had to obtain the consent of her bridegroom's father. Thus we read, "The day that the woman A is seen with B, he shall bring her to the wedding house. If she does not say to the master of the wedding house, 'Send for C, the father of B,' then she shall wear the sign of a concubine." Her mother was present at the sealing of this agreement. From this we may deduce that weddings took place at a definite spot, called the wedding house. The name was literally house of the males, or of the named ones, and also house of the Marbane, or sons of ancestors. It is clear that this was a registration court, where all who had pretensions to ancestry or were people of position were enrolled. One whose name was found there was a man with a name, also a son of an ancestor. He was probably registered there at birth, marriage, and death. The master of that house was a registrar and evidently could marry people. It was expected in this case that the woman, if she wished to be properly married, would send for the bridegroom's father, whose consent was necessary. Another name for the house was Bit Pir Sodom, the meaning of which is obscure. But, as Ishtar was Belit Pars, the lady of the Pars, we may connect it also with weddings. The bride's dowry. We have seen that the terherb karoni telatu, or present made to the parents by the suitor before marriage, was usually handed over to the bride on her going to her husband's house. There is frequent reference to this essential preliminary. It had to be carefully laid aside for the young man by his mother or brethren if he had not married in his father's lifetime, and was secured to him by law apart from and above what might come to him as a share of his father's property. Otherwise, he would suffer loss in having to find it out of his own pocket when his married brothers had been provided with the means during their father's lifetime. Usually, it was an amount of silver, 1 shekel, up to 3 minas. In later Babylonian times, there is little evidence of the parents receiving gifts. We now and then find it so. Thus, a man gave a slave and a mina and a half of silver for his wife to her mother, but it is not clear whether or not this was to buy her marriage portion. A far more valuable endowment of the bride was her marriage portion. If her father was not alive to give it to her, the duty fell on his heirs, and she had a right to it over and above her daughter's share of his property. Thus we find that the brothers, on giving their sister a share, contract to further endow her if she marries. Her trousseau. We have 1 or 2 lists that show what might be expected as a trousseau by a Babylonian bride. One, which illustrates the code extremely well, narrates first what had been given a notary and nubar of Marduk by her father on her taking her vow and entering the temple of Anunitum. This was his grant to her and was known by the same name as the marriage portion of a bride. It included half a shekel of gold for a nose ring, 2 shekels of silver as a finger ring, another ring of silver of 1 shekel, 1 malumsa, 3 cloaks, 3 turbans, 1 small seal worth 5 minas, 2 jewels of unknown character, 1 bed, 5 chairs, 5 different sorts of things apparently made of reeds. The concubine, Seratum, her stepmother. Unfortunately, many of these renderings are still quite conjectural. It is interesting to note that the father left to his daughter his concubine, who was probably a slave and possibly really the girl's mother. But now this girl is about to marry, and her own mother, Shubaltum, at any rate, her father's full wife, together with her brothers and sisters, give her all this property and cause it to enter her husband's house. They had a reversionary right to her property, since as a votary she could not alienate it from her family. So now they waive their right, as it will, after her marriage, pass to her children if she has any. So they are said to give her what her father had already granted her. Further, they return to her husband the tereb corona talatu of 1/3 of a mina of silver, which he had presented to them. The marriage portion could not be reclaimed by the wife's family at her death if she had children. If she had none, it went back to her family. Nature of the marriage portion. Another long list, also a grant to a votary, is found in 2 documents which contain apparently a complaint of oppression made to the king. Neither is sufficiently complete to be decisive as to the purpose of the letters or reports which are written in the first person, but they are duplicates as far as they preserve the list and in many other long phrases. Here is the list. 4 of gold, 2 rings, 2 dishes carved with karaku birds, 1 dish carved as a lion whose head is of abwood and its border of kuwood, 1 chair of kuwood, 3 chairs of different makes of abwood, 1 oil pot, salah, 1 oil pot containing 200 k otelska of Carchemish work, 1 mixing pot of copper, 1 dupru keku containing 30 k otelska, 2 kundulu of copper, 1.2.1 for. Although this list is full of words of which the meaning is obscure as yet, one can see the main drift of it. Jewelry, household furniture, pots and pans, and whatever went to the domestic equipment of the house. It is of interest to note that already Carchemish was celebrated for its wares. With these lists may be compared the Tel El Amarna lists given in transcription, with a few hints at translation by Dr. Winkler. They are lists of presents sent by a king of Egypt to a king of Babylon, by Dushrata, king of Mitanni, to Nimuria, king of Egypt, as the marriage portion of his daughter, Tadu Karonipa, and another list of her dowry. The greater part of the names of these articles defy translation. Later, usage during the 4th dynasty of Babylon, the celebrated Michaux stone, records the gift of lands by a father to his daughter on her marriage. From Kassite times, we have a list similar to the above, but not easily translatable. The supposed examples of dowry in Assyrian times are not really such. But in the later Babylonian era, the marriage portion was still given by the father. It bears, however, the name Nudunu, once reserved for the husband's free gift to his wife. The Nudunu in one case is 10 minas of silver, 4 maidservants, house furniture, and the like. It might include sheep and oxen. See also the later Babylonian laws about the marriage proportion. A long list might be made out from these sources of the house furniture, but as before, we do not know what half of the terms mean. Payment of the marriage proportion. There are many examples of receipts given for the marriage proportion received in full. Sometimes it was merely promised. It was not always paid promptly. Law C made a note of this. The father might have promised a portion and even given a deed of gift for it to his daughter. But if his means have diminished, he cannot be held to a literal fulfillment of the promise. He may do what he can. The law adds significantly that father-in-law and son-in-law shall not oppress one another. We find that actions were frequently brought to obtain a marriage portion. We have an instance where the payment was withheld for 9 years. Wife's pin money. A husband might make a settlement on his wife. In the time of the code, this was called a nudunu. It had to be by deed of gift. It might cover income-producing estate as well as personal property, but it was hers only for life. She could leave it as she chose among her children of the marriage, but not to members of her own family. We may regard it as pin money. Her husband's heirs could not disturb her possession of it as long as she lived, but she forfeited it if she married again. The period of betrothal. The betrothed maiden did not at once leave her father's house. This we learn from the code, which enacts a penalty on one who should seduce a betrothed maiden living in her father's house. It seems that on both sides, betrothal took place in early life, and that the arrangements were in the hands of the parents. A father was expected to take a wife for his son. The wedding ceremony, neither the code nor any contracts throw light upon the marriage ceremony, but a tablet published by Dr. Pinches in the Proceedings of the Victoria Institute, 1892-93, reprinted as Notes on some recent discoveries in the realm of Assyriology, contains certain suggestions. It is very fragmentary and in the form of an interlinear translation from the Sumerian. It is not always clear who are the actors referred to, but we may perhaps take it that the officiating ministers, priests, or elders first placed their hands and feet against the hands and feet of the bridegroom. Then the bride laid her head on his shoulder, and he was made to say to her, I am the son of nobles. Silver and gold shall fill your lap. You shall be my wife. I will be your husband. Like the fruit of a garden, I will give you offspring. Then there is a wide gap. But in the next column, we seem to have a further part of the wedding ritual. The officiating ministers ceremoniously bound sandals on the feet of the newly wedded pair, gave them a leather girdle or strap, and fastened to it a pouch or purse of silver and gold. The further ceremony included placing them somewhere in the desert. Then, turning their faces to the sunset and addressing the man, the minister says, I swear by the great gods, and you may go. He bids him not to put off the garment of Ea, nor something belonging to Marduk of Eridu. Then comes a wide gap, but the fourth column seems to read, until you have settled in the house, until you have reached the city, eat no food and drink no water, taste not the waters of the sea, sweet waters, bitter waters, the waters of the Tigris, the waters of the Euphrates, waters of the well, nor waters of the river. To fly up to heaven, direct not your wings, to burrow in the earth, set not your dwelling. As a hero, the son of his God, let him be pure. The passage is very difficult, and much of the rendering is conjectural, but the point of the address seems to be that the young man was to go straight home, live with his wife, and be good, as a true child of God. The first column seems to be an enumeration of men who are cursed with misfortunes. For example, one whom his mother brought forth with weeping, and perhaps forms part of a prayer that the bridegroom may not ever be like such men. We must hope someday to find a fuller text and so to determine the connection of the various columns. But it is difficult to imagine what else the text can be than part of a wedding ceremony. The first home. The young couple did not always set up a house of their own. They often went to live with the bridegroom's father. This is shown by the penalty fixed by the code for the seduction of a daughter-in-law by a father-in-law. The daughter-in-law was living in his house. Monogamy prevalent in early days. In the earlier days, monogamy prevailed. A man ordinarily had one wife. Polygamy, however, was not unknown. For a variety of reasons, men did sometimes have two wives, but these cases were treated as exceptions. A man might also have a concubine or a slave girl to bear him children. These did not bear legitimate children. He might adopt them, but was not bound to do so. If a man married twice, the children of both marriages shared equally in his possessions, but they did not put their mother's marriage portions into a common fund and divide that equally. The children of the first wife divided among themselves their own mother's marriage portion, and the children of the second marriage did likewise. Polygamy in later times. In Assyrian times, there is clear evidence that among the slaves and serfs at least, polygamy was fairly common. In the later Babylonian era, polygamy also existed. Wives might be sisters. We read of a second wife. But taking a second wife was held to be a slight upon the first, in whose marriage contract the clause was inserted that in such a case the husband must pay her a mina of silver and allow her to go back to her father's house. In that case, the man was hardly bigamous. It was a case of divorce, and perhaps a legal ceremony before judges was also necessary. Concubinage. A man might form a connection with a woman other than his wife. A concubine was a free woman but had not the status of a wife. Nevertheless, she might bring with her a marriage portion, over which she had the same rights as a legal wife. She was taken into the same house as the wife, but she might not rival her. A man's excuse for taking a concubine was that his wife was childless. He was not allowed to take a concubine even if his wife was childless if she gave him a maid to bear him children. Only when the wife was herself childless and would not allow him a maid was he allowed to bring a concubine into his house. This second wife was married to him. She often seems to have been bound to serve the first wife and treat her as her mistress, but she had the same rights as a wife. If she were put away, the husband had to return her marriage portion, if she had any. She had the usufruct of house, field, and goods. She was not deprived of her children, but had the custody and education of them. When they entered into possession of their father's property, she shared with them, taking the same share as a child. Then she was free to marry again. It seems that in any case, the children of a concubine were full children and with the same standing as the children of the first wife. The father might dower his daughter for a concubine. She then had no claim to share with her brothers and sisters at his death. But if her father had given her no marriage proportion, her brothers must give her one at the division of his property. The maid as the wife of her master. The case was different with the maid, a slave who by her mistress's consent bore children to her master. She was still a slave, and if she rivaled her mistress or was impertinent to her, she could be put back again among the slaves, perhaps even branded. But if she had borne children, she was not to be sold as a slave. At the death of her master, she was free. Her children by him were free in any case. If her master were so minded, he might make them full sons by verbal acknowledgement. It was enough to say, "my sons." But that he had done so probably had to be proved by a witness. A family unacknowledged by the father would on his death have only a mother. In such a family, the mother was the obvious ruler. We must be on our guard against mistaking her position or that of the concubine above for examples of matriarchy. If she was pledged for debt, she could not be sold, she must be bought back. Marriages and inheritance among slaves. That a slave usually was married to a slave girl with his master's consent, and even by his direction, is quite the rule. Masters even went so far as to buy a slave girl to be wife to a slave. There is no reason to think that the master did not respect the slave's matrimonial rights. But the slave's wife was not always owned by the slave's master. Sometimes she was owned by a different master, or was free. There was no especial disgrace attaching to becoming the wife of a slave. A free woman might not only marry a slave, but bring with her a marriage portion as if she had married in her own rank. The man had no ancestral property, he was a son of no one. Hence, when he died, all the property to be divided consisted of what the married couple had acquired together and the wife's marriage portion. To the latter, she had full and unquestioned right. The master was his slave's heir. So the property which the pair had acquired during their married life was divided into 2 equal portions. The master took one half, the wife the other, for herself and her children. The children were all free. When both father and mother were slaves, so were the children. There was no property then for the slave children to inherit. Data from the contract, some further evidence from the contracts is worth noting here. Documents relating to marriage are not very common and may have owed their presence in the archives to some peculiarity in their form. Some are perhaps rather a memorandum that the proper formalities have been complied with. Thus, we read that A has taken to wife B, the daughter of C, from C and D, his wife, and has paid 10 shekels as terob koronatalatu to C, her father. The rest is lost. If it only laid down the penalties for infidelity on either side, this was quite normal. Fatherless girls, whenever the mother alone appears, as giving her daughter in marriage, we may suspect that the father was dead or the mother divorced. When the mother is a votary, we know that such a person was not entitled to have a daughter at all, and hence we are not surprised that the terob koronatalatu offered for the girl is small, 5 shekels or even 1 shekel. So the penalty laid upon the man for divorcing such a wife is only 10 shekels. On the other hand, if she was unfaithful, she was to be drowned. The marriage of votaries, very singular are the cases in which a votary marries. We know from the code that this sometimes took place. But the votary seems to have been expected, though married, to keep her vow of virginity. In one case we read that a woman first devotes her daughter, Ulilsi, then marries her and declares at the same time that she is vowed, alit, and that no one has any claim on her. Power of agnates. In some cases, a sister had the power to give her sister in marriage, with the declaration that no one has any claim on her. We may imagine the sisters orphans, without brothers. The name of their father is, however, given, and his sons and daughters are mentioned. It seems to be closely parallel to the case of the marriage of a king's daughter, where a sister also gives a sister in marriage. Here, Elmeshu, daughter of the king Amidatana, marriage of a king's daughter is given in marriage by Zertum, also daughter of King Amidatana, on the order of her brother Shumom Libshi. The bridegroom was Ibku Anunitum, son of Shamash Lemur and Taram Shulum, his wife. The parents paid for their son only 4 shekels as terbkaro nitalatu, which Shumam Lipshi and Zertum received. If the bridegroom repudiated his bride, he had to pay half a mina. It is not clear what penalty the bride had to pay if she repudiated her husband. This is dated in the reign of Amidatana, but in which year of his reign does not appear, as the traces of the year name do not agree with any in the chronicle. It must then have fallen somewhere between the 7th and the 22nd years. Hence, the father of the princess was alive at the time. Why had he no hand in the marriage? The history of the reign is not very well known. Perhaps he was away from home. His son and successor, Amizaduga, whom we may imagine to have been the eldest son, does not appear in the case. Perhaps he also was away. But it is remarkable that the king never does directly take part in any contract. That is probably due to his sacred character. The young princess was not treated with overmuch consideration, judging by the smallness of her dowry. Marriage of 2 sisters to 1 man. We have a very singular case in the marriage of 2 sisters to 1 man. This has already been translated and commented upon by Meissner, Inches, and Sayce. It is, however, too important to omit here. There are 2 tablets concerned with it. The first is the contract between the husband and his wives. We may render it thus. Ardishamash took to wife Taramsagil and Iltani, daughters of Sinabushu. If Taramsagil and Iltani say to Ardishamash their husband, "You are not my husband," one shall throw them down from the Anzag Garkai. And if Ardishamash shall say to Taramsagil and Iltani his wives, "You are not my wives," he shall leave house and furniture. Further, Iltani shall obey the orders of Taramsagil, shall carry her chair to the temple of her god. The provisions of Taramsagil shall Iltani prepare. Her well-being she shall care for, her seal she shall not appropriate. Then followed 10 witnesses, but no date. The second document seems to be drawn up rather from the point of view of the sisters. We may render it thus. Iltani, the sister of Taram Sagil Ardi Shamash, son of Shamash Shenam, took to wife from Utatam their father. Iltani shall prepare the provisions of her sister, shall care for her well-being, shall carry her chair to the temple of Marduk. The children which she has borne or shall bear shall be their children. If Trama shall say to Iltani her sister, "You are not my sister," shall say to Iltani her sister, "You are not my sister. You are not my sister." If Iltani shall say to Tarim Sagil her sister, "You are not my sister," one shall brand her and sell her. If Ardi Shamash shall say to his wife, "You are not my wife," he shall pay 1 mina of silver. And if they say to Ardi Shamash their husband, "You are not our husband," one shall tie them up and throw them into the river. Here there are 11 witnesses, but again no date. Meisner deduces from the mention of children that Tarim Sagil was already married. The exact relation between the sisters is not clear. In one case, they seem to be daughters of Utatam, in the other of Sinabushu. Or it may be that Iltani alone was daughter of Sinabushu. If so, perhaps Utatam had adopted her. Sayce clearly thinks so, but they might be daughters of the same mother by different fathers, one of whom is mentioned in one case, the other in the other. Or they might really be children of Sinabushu if their mother afterwards married Utatam, who was thus their stepfather. It is clear that Iltani was to wait on her sister, and if she repudiated her, was to be treated as a slave. This is exactly parallel to the status of the slave maid, whom a wife or votary in the code provided for her husband. Perhaps Tarim Sagil had become a chronic invalid. A comparison of the two texts is interesting in other respects. The penalties differ curiously. If Ardi Shamash repudiates his wives, in one case he loses house and furniture. In the other case, he pays 1 mina. Was one the penalty for repudiating Tarim Sagil, the other for repudiating Iltani? But if they repudiate him, the penalties are different in the two documents. Unless, indeed, the Anzag Garki be an ideogram for the steep place from which they were to be thrown into the water. Marriage with attached conditions. Marriages are not infrequent, which impose conditions upon the husband and wife with relation to outside parties. Thus, a mother gives her daughter in marriage to a man on condition that she shall continue to support her mother as long as she lives. In this case, if the husband put away his wife, he was to pay 1 mina of silver, while if she hated her husband, she was to be thrown from a pillar, dindu. This pillar may be the real meaning of the Anzag Gargai, which looks very like an attempt to express ziguratu, a tower, in an ideographic way. A very similar case is where a lady takes a girl to be wife to her son but stipulates that the wife shall treat her as mistress. If she shall say to her mother-in-law, "Thou art not my mistress," she shall be branded and sold. As long as the mother lives, they two together shall support her. One may suspect that such maternal power, as is here shown over the children, arises from their having been adopted by their mother in order to provide for her in her old age. This was often done. The children may have been slaves before adoption. In the second case, the mother leaves her son all she has or may acquire.